medically, physically challenged candidate, my lord. My lord, in the second SLST, my lord, he have filled up his form accordingly, my lord. My lord, what happened, my lord, during the verification process, they have rejected my prayer, showing that I am a general candidate. My lord, I am a PH candidate. I have all these years I am serving through as a PH candidate, my lord. What happened, my lord? My reservation has now termed as locomotor disability. In locomotor disability, my lord, according to the statute, my lord, I am entitled to get 1% of reservation, my lord. But they have omitted that reservation. And now the PHOH has been termed as physically challenged others category, my lord. My lord, in my grievance, my lord, I am a locomotor disability and I am entitled to get 1% reservation. So in my category,
So it's just a verification.
they have rejected my candidature, my lord. Since, my lord, I have mentioned I am a PH candidate, and they
Right. So they treat you as general.
yes, they have
They will
treated me
treat you as general.
and showed me that I have secured less marks than the cut-off marks.
All right. File it in the department.
My lord, can it date be fixed, my lord? My lord,
No, next Monday. Next Monday.
I'm deeply obliged.
In the department. In the department. Chiradin, in the department.
May I file and give the number?
Yes, file and give the number and intimate your other side.
May your lordship be part.
My lord,
1 minute.
for inclusion contempt matter.
No, sorry, no inclusion.
Inclusion contempt.
No inclusions.
My lord, the transfer matter, my lord. One
Transfer matter upgradation give.
For upgradation, lordship.
And
Lordship,
pin.
upgradation item number 1004. Lordship, the father of the petitioner died before.
I do not want the history. What you want?
Your lordship, the petitioner wants the job under tied in harness category, but is quite eligible, but is not getting the job.
Is the matter there in the list?
Yes, your lordship, 1004.
1004.
Yes, your lordship.
It near into 1004. Compassionate appointment.
Ladyship's time leave to mention.
What is the matter about?
This has been started in a long back, but the appeal has been disposed of.
No, but then I am neither including nor upgrading matters only. So no upgradation, it's only
2015 he was writing an appeal prepared by the SSC, that was disposed of.
please excuse for this month, please excuse.
And the appreciation of this lady is out.
Sorry, yes, yes.
More than
Sir, please, yes.
Permit to mention, my lord, will aware that fact that, my lord, Group C, Group D online application is going on.
Yes.
Last date is 3rd.
Third.
My lord is well aware the fact that the Supreme Court in the judgment gave the age benefit to all untainted candidates, but they only give benefit to the untainted, not specifically tainted teacher. So, my lord, we are entitled. We are waitlisted candidate.
They are not giving the benefit.
Not giving the benefit. So
All
that's
right.
why, my lord, necessary. My lord, kindly
Tomorrow.
take day after tomorrow.
Day after tomorrow, very well. Day after tomorrow, and in that case, serve.
Yes, I will serve, my lord. That's why, my lord, I will.
Day after tomorrow.
Your lordship, may I be permitted to mention on second?
In Group C, Group D category, my lord, they only publish the tainted list of 3,512 candidates. According to the judgment, my lord, 6,304 candidates, they are OMR manipulated. My lord, I will show, my lord. Yes, I will canvass, my lord. So, my lord, at the time of. So, my lord, on
Day
part.
after tomorrow.
Grateful.
Item number.
No, why upgradation?
Lordship, the petitioner has been participated in the examination date 2011.
Yes.
Lordship, and the responded authority already issued appointment letter, Lordship.
So
But they did not have taken any step, Lordship. Till now.
you have been issued appointment letter.
Yes.
Then what are you? Why are you coming to court? You got the appointment letter. Go and join.
Lordship, the respondent authority does not do anything.
Sorry, you are not ready. No inclusion.
Lordship.
Give the numbers. Give the numbers.
Your lordship was pleased, kindly remember, your lordship was pleased to grant me leave in respect of matters where the teacher's code was required. Your lordship was pleased to grant me leave to move today, my lord. The matter is, my lord, 1679, my lord. The interview is on. If I get that teacher's code, then I'll be entitled to the 10 marks.
Who is going to give you the teacher code?
My lord, my contention is that teacher's code cannot be a mandatory field because we are, my lord, persons who have been working in the recognized minority institution.
No, sir, I'm not upgrading. Let the matter remain over there because the SLST matters are going on. And
Kindly hears that
issue-
also. If in 10 marks
Any-
goes, then I'll not be. This will
yes,
be
yes.
infraction.
So just
But
wait.
if doesn't go, then I'll be entitled to 10 marks.
Wait,
Can-
because the entire issue is there before the court,
Yes,
and
yes, I understand. But then let
whether
this be also taken up along with these
the
group matters.
contractual appointments, central government, and
Yes,
there are
I was there in the previous matter, my lord. Then let this be taken up along with the bunch.
let it remain with you when those matters are taken up, just not at the time of
My
mentioning.
lord.
Please
Your
wait.
Lordship,
May I hand over this?
No, keep it with you.
My lord, I am mentioning new transfer matter for inclusion in the list.
No inclusion, sir. I'm mentioning it.
May I permit to mention that in the monthly is 1155, that petitioner is 87 years old. I'm paying for retirement benefit, my lord. Petitioner is paying for retirement benefit,
87 years old.
87.
He retired in 60 years of age, right?
60. Yeah.
Right?
Yeah.
27 years, what was he doing?
My lord, his representation is given.
Representation.
Representation is given.
Sorry, I'm
Lordship,
refusing.
may I
your
permit
prayer.
to mention on second SLST matter where the petitioners have been deprived of their 10 marks regarding their prior teaching experience. Your Lordship is taking up similar matters. If your Lordship is kind enough to tag this matter with those,
Is it there in the list?
Lordship, not yet.
Not yet.
Your Lordship.
All right. Give the number. When did you file it?
Your Lordship, last week.
Last week. This is second SLST matter. Aki banche ঢুকিয়ে দেবেন.
Grateful.
Your ladyship, kind leave to mention, this is a restoration application, your ladyship.
You want inclusion?
Yes, your ladyship.
Please do not mention. No.
I may be permitted to mention a matter for upgradation. It is in the monthly list as item number 16.
Why upgradation?
Ladyship, the candidate was a participant of the SLST 2025, and there has been some problem with the appointment and the results. So,
Appointment given 2025?
not appointment, your ladyship, with the examination.
Yes.
During the examination, he had some problems and he could not attend to it because of the payment process. There was a problem in the payment process.
Right. Payment process was in month of sometimes in September.
Yes, your ladyship.
September or maybe prior there too. Why are you here now?
Your ladyship, after that, the petitioner had made representations, but the
Represent. Give the number. It to be mentioned, Raghavan. To be mentioned. Serve notice upon your other side.
Upon notice to the other side, I am mentioning item number 989 of
For what?
today's list for upgradation.
Why?
My lord, petitioner participated in this TET examination of 2011. He qualified. Thereafter, my lord, he called for verification. Verification done. They assured that the appointment will be issued. So till date, my lord, nothing has been.
Nothing.
Nothing.
Nothing. Please wait.
My lord,
Please wait.
For 4 matters for transfer and 2 pension.
Give the numbers if it is there in the list.
kindly to mention an application for recalling. My lord.
You want enlistment? Sorry, sir. You are already out of breath. You've come and I'm refusing prayers.
There is some
I'm sorry. No, sir.
My lord, there is some urgency in a contempt, my lord, case.
Not including, neither am I upgraded.
My lord, there is extreme urgency.
No, sorry.
Kindly, my lord, consider.
For
Lordship's order.
for motion.
No inclusions. Call the
My
list.
lord, your lordship's order, my lord, restraining a party from carrying on construction, my lord, there's a building now coming up in violation of your lordship's order.
Yes, 7. Mr. Anjan Bhattacharya. Item 7. Is it your matter? Not your matter? I dismiss it.
No, no.
Abhishek Kumar.
Hmm.
What, who?
But
It's a 2021 matter.
only one day accommodation. I simply missed the list. দেখো না লিস্টে আছে মামলা।
Acha,
Okay,
other
fine.
side, is anybody there? I've got an order
We
sheet.
fixed it.
Hearing for the first time. I'm told it's a 2021 matter. What is this?
But the date is fixed on 4th.
And it was there in the list for the last 3 days.
No, the matter has been fixed on 4th. That's why huh? দেখুন তো লিস্টে পিছনে লেখা
Who
আছে।
has fixed it?
May I get it? May I see the list?
Consider it.
লিস্টে লেখা আছে 4th.
You want consideration of annexure P3? Final order of transfer.
Well, may I get only one day accommodation?
Not today.
কালকে-
Or do one thing. I'll keep it day after tomorrow. You serve.
Absolutely.
I serve the other side.
No. Purely.
Keep it on the 3rd.
But I'm so sorry. But I simply missed it. দেখো না। আরেকটা আছে? একটা আছে।
I am for the petitioner, my lord. It was that vocational teachers matter, my lord. On the last occasion, your lordship directed them to come back with instructions, my lord.
নাম দিতেই তো এসছো তুই তো।
My lord,
Honest.
one point was taken that we are not teaching the
Whom
regular
was they?
subject.
Kumon.
He was he saw him
Yes, he mentioned
Hey,
what
yo.
matter.
বাইরে বাইরে দাঁড়িয়ে ছিল ওই রোগা করে।
Whether the petitioners are serving against substantive posts or
My lord,
not.
I have taken instructions, but your lordship recorded that he is supposed to take the instruction. I have taken
My lord,
instructions.
I have
and they are
also
not
come up
working as
with-
substantive post.
My lord, I have also come back with instructions, my lord. Firstly, it was submitted that we are not teaching regular subjects, my lord. My lord, this is a curriculum of the department, my lord. Kindly see the right hand.
What do you teach?
My lord, this particular subject, some teach Bengali, mathematics, my lord.
Those are
Kindly see.
vocational, not regular subjects.
No, these are vocational mathematics, vocational, in vocational stream, we teach regular Bengali, regular mathematics and subjects. And my lord, see, kindly see the syllabus of 10+2. That is
Huh.
what I produce before your lord.
Yes.
আমাকে দাও না, copy note please. My lord, kindly see এই যে ভাই সিলেবাসটা বার করে দাও। যেটা ওখানে
Any
বার-
instruction, Mr. De?
My lord, these appointments, my lord, so far the notifications are in their engagement. It says my lord, that there is no work on this point of any substantive post. Moreover, my lord, kindly perusal page 24 of the writ application. How it has been fabricated and how, my lord, this is on state part, Mr. Bandyopadhyay will, and that the headmaster, how the headmaster can modify an appointment letter and issued in a duplicate 25th, 2025. First, my lord, kindly see
One minute. Page 24 is not a
24,
proper
his
document.
engagement is part-time.
Yes, it is written first time.
Part-time, how it can be substantive post for a part-time? It is for ad hoc appointment. No, the feature of any substantive post are attributed to this. Next,
What, according to you, is a substantive
there
post?
should be a scale fixed. There should be a benefit, but there is only an ad hoc appointment to run
What,
the
according to you, is a substantive
is the
post?
regular teachers, like the regular teachers, the post is sanctioned, the post is created for a particular school or centers, it is created by the government. Here only this engagement to run the VTCs. No manner of any substantive nature has ever been given sanctioned by the government. Now this is a part-time, and next one, page 26, how the headmaster can say is modifying with reference
Page 24 is
to
from
part-time.
IOMS.
Yes.
Right.
Yes, RUMS, Kaushik Roy, remuneration detail, engagement status.
Yes, part-time. It is
Part-time.
mentioned
Next,
part-time. So where
part-time.
is the fake thing you say?
No, next
Page
one.
26.
Next, page
26?
26. Not fake, but how the is when modified, the manage the headmaster. He says
27, 26 and 27.
2026.
Ha, 20,
With reference to the you are hereby requested to join in the said substantive post in which we have never been into this kind of appointment where headmaster is
All right, this is
Next.
not.
similar one is page 28. This part time
27 also.
27 also.
Third line.
Yes.
Substantive post.
This headmaster should buy an affidavit.
What do they teach? Mathematics. Page 27 teaches mathematics.
Vocational.
Vocational. My lord,
The
that-
vocational teacher.
That is only restricted to the VTC, Vocational Training Center.
Yes.
And these are not compulsory subjects also.
Will they not get the teaching experience?
No, they are not working as any substantive post. They are not teaching any compulsory subject. They are not in a sanctioned post also. My learned friend is absolutely correct. Let these headmasters who have issued these, maybe for the good of the teachers, I do not go into the intention, but let them come and give an affidavit that they are working in a substantive post. We'll take it up from there.
My lord, what
No,
is
you
substantive
bring it up.
post, my lord? May I learn?
government has ever sanctioned. It is for the government to say none of we are from the council only. We can only just allot the fund after getting it from the government. But none of the we have been ever instructed.
You allot funds to the petitioner. You pay salary.
No, that is for the VT centers. And then
Center pays.
center-
Pays our salary.
No,
And-
that may come. That is for ad hoc.
That may come.
Where from is the money coming? Who's paying the salary of the teachers?
No, salary of the teachers obviously is coming from
Schools.
the government fund.
Yes,
From the school
schools are
fund.
paying. Schools are paying.
No, schools are paying is different. And one thing is
No, you don't say school. You say center. School and center.
No, it is a vocational training center.
In a
It
school.
is attached with the school.
Yes.
It is in a school.
Regulars class and whoever opts for the vocational subject, vocational higher secondary, they will be through these vocational training centers. And all their nature are the part-time, someone is contractual, is part-time, and ad hoc fund is allotted, that is of 2006 government notification, there's a lump sum is allotted.
If there is no fund, they will not teach.
Yes.
And they do not get any proper pay scale.
No scale is there. Ad hoc, only on ad hoc council.
But for example, your lordship may take one of the appointment letters, engagement letters at page 34. It's the wordings will give a clear picture, my lord. If I may place it in its entirety, engagement, this is one Rajkrishna De, engagement to the post of contractual teacher for the subject of MPAP.
Anyway, no use going into all these things. It is for the commission to decide whether it
may
is
I,
a
my lord?
course or
Only
not.
one thing, my lord.
The commission says it is not a substantive post. Now the court is deciding
My lord, only one thing.
the
Firstly,
rules
it
and
is-
everything. 10 marks
firstly,
you'll get or not.
I don't understand where the petitioner has committed any fake or fraud. I don't
No,
understand.
no fake or fraud.
Kindly see the
Secondly,
second bullet point of page
admittedly,
30.
admittedly, my lord, I am working as a part-time teacher and my salary is being paid from the exchequer, government exchequer. Now, my lord, only question which boils down to what is substantive post. My lord, it has been specifically stated by the Supreme Court what is a substantive post and what is to be taken.
See, the rule is under challenge. So right now, it's no use going into all these things.
1984 SCC 226. My lord, here, my lord, Supreme Court says that whether temporary, whether part-time, it doesn't matter. The capacity in which if the appointment is a regular appointment, process is a regular process, and it has been approved by a competent authority, it is a substantive capacity. The person holds the post in a substantive capacity. And in my case, my lord, all the three criteria are being fulfilled.
Whether prior teaching experience marks can be allotted in favor of vocational teachers.
Yes.
This is the issue.
Yes, my lord.
Very well. Please come.
And my lord, on the last occasion, I have also placed a judgment passed by your lordships that vocational teachers are entitled to 10 marks for experience in respect of the last selection process.
All right.
Last selection to 10 marks children.
2021 in 12th
2011.
12th LST.
So teaching experience was there. You are
The
accepting that.
petitioners are
So in Bengal it was
Uh,
there. You are accepting that part at least.
vocational teachers.
Yes, in Bengal it was there.
Stuff.
It was
They
separate.
participated in
10%
the
seat was reserved for
second SLST, 2025. Stuff. They seek marks on account of prior teaching experience. Respondents, prior teaching as the petitioners do not teach in substantial posts, they will not be entitled to marks
My lord,
on
I am appearing for
prior
the
teaching
School Service
experience.
Commission.
The issue as to whether vocational teachers can be treated to be teaching in substantive posts or not, enabling them to be awarded marks on account of prior teaching experience is to be decided. Stop. The process of credential verification and thereafter interview will follow. Stop. The as the issue is under active consideration by the court, accordingly, any steps taken in the recruitment process shall abide by the result of the writ petition. Let us see what can be done. Do you all want to file a report or affidavit, something?
Malad, affidavit
Let-
we may file. But Malad, any steps taken, Malad, vis-a-vis Malad, the petitioners, kindly.
Petitioners, vis-a-vis the petitioners, definitely not for all. Yes,
His voice is breaking up, I think.
let the commission, the commission, the state and the
Council.
vocational, now West Bengal State Council of Technical and Vocational Education and Skill Development file a report with regard to their stand, report by way of an affidavit, with regard to disclosing their stand within a period of by 12th.
Note करके रखो, report देना.
It will be open for the petitioners to file exception to the same.
But we will also file. We will
Yes,
also
sir, time has been given to you. Release the matter for further consideration on 23rd of December.
But we will also file.
It cannot be done.
Am I audible to your lord?
Your sound is breaking, sir.
Am I audible?
By that time, it may come to an end, my lord, every process.
Maybe, but then since the court is in scene of the matter, let us see what happens.
राहुल पे तो बोला था होता है होना ही अच्छा ना
What is the next one?
मेरा नहीं है
But for the petitioner, this is regarding mismatch in the model answer key and the question. Last occasion, Lordship directed the commission to come with a report. Before that, my lord, I have a specific I have a specific submission to make in this regard. My lord, while going through the issues, various issues, we found 3 types of irregularities. One is when there is 2 options are possible. One has been considered, one has not been given importance in terms of the text. One category. Second category is the question itself is wrong or the model answer are not commensurate with the question or it is out of syllabus. 2. Third category is that when there could be a definite answer, but the marks has been given to all. These are the 3 basic categories. Before your lordship takes it up, I request only one page to take, page 74. There is one anomaly, it has been indicated subsequently. Kindly take page 74 for once. This is the final model answer key. It is beginning the, my lord, kindly see the final model answer written, page 74. 74, kindly see, there is something I found out that 75. Kindly come to page 75. Just take for example, my lord, the left-hand side column, marks on attempt, lordship has found. Marks on attempt, then marks to all. Marks to all, marks on attempt. But a very pertinent question comes today. Why marks to attempt and marks to all? What is the difference? Why two separate expressions have been used? Now, meaning there, by my understanding is, marks on attempt means this question has to be attempted. Whatever answer you give, you get marks. One. Now, marks to all. That means, irrespective of I attempt or not, anybody can get marks. Otherwise, these two separate expressions would not have been used in the model answer key. But going by this, whoever even leaves these questions would be entitled for marks. That cannot be permitted in a public recruitment process. Why these 4 questions? If I take one, this commensurate with 2-3 questions are like this of marks to all. Marks to attempt is a different connotation altogether. My lord, I understand marks to attempt can be given, or marks to all can be given to candidates where the question is disputed.
All right, let me hear them.
And
what
this
does this
category
mean?
of, and only one thing, my last occasion, lordship wanted to see the objections I handed over. It was not inadvertently with the part of the writ petition. This is the preliminary objection I submitted. Which
This has to come by way of
last occasion, your lordship directed to give the copies to Mr. Singh. I had handed over. I had handed over to Mr. Singh. He had received. Yes, I sent it through what he asked me to give through WhatsApp. I sent that your lordship only wanted to see whether I had raised objection. And my lord, so far my questions are concerned, 2 are out of syllabus. 2, there are definite answers where option A and C both are correct, but option C has been taken. Another question where option A and D both are correct, only option A has been taken. 2 questions out of syllabus where all answers to be correct, but only one model answer has been taken. And my lord, rest 2, there could be only specific answer C, but A and C both have been taken by diminishing the competitive edge and the level playing field. Now, my lord, the rule, it is very important, my lord, just one line of the rule is very important. If your lordship kindly takes for once one line, I will just show, kindly come to rule 11 for once. 11 Roman 5.
No.
Lordship has found Roman 5.
Yes.
But kindly see what is the language of the statute. The Central Commission shall publish in its official website preliminary model answer keys after the written test and may invite suggestions and or objections from the applicants. So the legislative intent was very clear, not only suggestions at the discretion of the authorities, suggestions and or objections. Both word has been used very specifically, not only suggestions, but objections when there are specific answers. Now kindly take the proviso. It says, provided that suggestions or objections must be submitted within 5 days after publication of such model answer keys and should be supported by at least 2 authentic academic publications. I have done so. But I pose this question to myself. What is the purpose of obtaining the books, textbooks, taking the objections and taking fees for it? If you do not entertain these individual questions, if you decide on your own, I pose this question to myself.
1 minute, they were directed to revert with a report.
Yes.
Is the report there?
The report is ready, but it is being affirmed, I'm told. Number 1, and we'll circulate the report. May it be taken up on Wednesday, Thursday.
All right, that is all right. But then page 74 of the writ petition, the final model answer key is annexed. What does this mean?
75.
Marks to all and marks on attempt. Page 75, you'll get it.
We'll have to take instructions and come back.
Does marks to all mean that there is no requirement of answering? No. That means marks to all 1, 2. 2 marks will be given to everybody who appears in the examination.
Yes. Appears so.
No, you have to answer any one of it.
I didn't get it.
Assuming a marks to all situation subject to correction, it presupposes someone has to answer that particular question, albeit wrongly, so as to enable him to get that full marks.
No, that means marks on attempt. What is the difference?
We'll have to come back. We'll have to come back.
My humble submission, this is
I have to come back.
the manner to do charity to candidates to
Bandyopadhyay
give
is there.
marks.
Brother, I am appearing this, brother.
Yes,
Brother,
please.
I am appearing.
This is
Am I
item
audible,
number
brother?
2.
Two. Am I audible?
Yes, I can hear you.
Now, brother, there is a report. Your lordships will find it.
Yes,
We
the
are-
report is not handed over.
Because it has not yet been affirmed as yet. There is a huge cloud. What has happened? I can just tell you, lordships. In short, I am telling you.
No,
that
I do not want. Let the report be given to the petitioner because petitioner doesn't know what is there in the report.
Correct.
He needs to come back. Only
Yes.
one query. If you please come to page 75 of the writ petition.
Yes, my lord.
This is the final model answer. There are, apart from the marks, there are certain words written. Marks to all and marks on attempt. What is the difference and what does the two mean?
My lord, if it is an out of syllabus, then marks to all.
That means out of syllabus.
Marks out of syllabus, they have marked, they have attempted, then in that case they will get it. Anyway, my lord, I will get the more clarification, I will come back. That would be better.
In that case, there are two questions where there are out of syllabus. That two had to be considered as marks to all. Then
no, out.
Those are not the ones reflected over here.
Yes.
Marks to all. 32.
Yes.
Is it an out of syllabus question?
32. I tell you, lordship, this is that would be. It's not an out of syllabus.
Lord,
this is
question is, Lord, whether in the preliminary objection he has raised the objection or not.
Yes, he has.
Yes, he has not raised the objection in all the questions that we are discussing in the affidavit. No, I am not correct. You are only correct, brother. Allow me to speak.
Report directed to be filed by the commission.
One thing, 4th is the date of
is yet to be placed on record.
This order of the lordship.
Stop. Let a copy of this. Let a copy of the same be served upon the learned advocate representing the petitioners for reverting with an exception. Stop. Release the matter on 10th of December. Certain matters are fixed on 10th.
The various, my lord, 4th is the date of verification. Your lordship has granted some relief in the previous matter.
That relief will remain.
That is abide by the result of the.
Yes.
I have handed over the copy of your lordship's order.
And you please file a supplementary annexing
Very
this
well.
because
Yes,
the submission is that you have not filed your objection.
I'll clarify.
It is granted to the advocate on record of the petitioner to file supplementary affidavit annexing document to show that objection was raised.
But we are annexing his objection in our report itself.
I will also do it.
What he is saying in the we will show what he has been pleaded in the writ petition that is not correct in every cases when our report will come.
In my supplementary.
He is going on something basis. His objection is something.
Yes.
To be prepared and circulated by 4th.
My lord, that relief may be given, my lord. This abide by the result. Otherwise, I'll be that order your lordship passed. It was not there in the previous because today your lordship fixed it because it is there.
Come. It has been submitted that the process of credential verification and interview is on. Stop. Next. As the matter is being adjudicated by the court, any steps taken by the commission in respect of the petitioners shall abide by the result of the writ petition.
May I take
this
back?
document
May I take
back.
back? May I take back?
It okay, Dilo, please return.
Grateful to Lord.
Yes, 3.
Can recollect the matter? This is that a transfer matter of the teacher who is the mother of a 4 months old child. My that has the last occasion directed the commission to consider this transfer.
Yes.
But this matter, Lord, we have considered this matter. He just see he is she is on leave up to 21st. 21st is entitled to get it. And Lord, within this time, kindly keep it pending. Lord, we will consider her case within this district itself, and kindly keep it after 21st. I think, Lord, that this matter will be considered by us.
After 21st, let
No.
her give the name at least.
No, this is Lord, we have to find it out.
You
She is
have to
already
find
on
it
leave on up to 21st.
Right.
But before that, your lordships can also keep it.
Yes.
But near to 21st, near to 21st.
All right.
But this matter will be considered by us, Miller. That's
All right.
chairman has said so,
Learned,
and we are trying to
learned
find out
senior
the
counsel
vacancy
representing
in the district.
representing the commission submits upon instruction that steps are being taken to locate a school close to the residence of the petitioner where her name can be recommended. Stop. Prayer has been made to adjourn the matter for the period during which the petitioner is on leave. Stop. On such submission, release the matter for further consideration on 18th of December.
I can hand over the the list of the schools which schools are nearby the petitioners.
And they are vacant?
No, Miller, that
Give a copy to the learned advocate, they will take instruction. Take down one line in the other matter. A list of schools handed over by the learned advocate for the petitioner where vacancies are allegedly available has been handed over by the learned advocate for the petitioner to the learned advocate representing the commission for taking necessary instruction. Yes, item 5. 4. 4.
The last location, the order was passed on 28 November, my lord. In para 3, there is a direction to produce the OMR sheet.
All right, yes.
Lordship, this is the sample one. This is a sample how the OMR sheet is there. But as far as the petitioner is concerned, Lordship, the scanning which was done by the OMR was truncated, or rather half has come. But the salvation is that the marks answer string, whatever answer that, Lordship will flip the page. This is known as answer string, Lordship, and whatever is there in the OMR sheet, that is replicated over here as to how many answers he has given or he has attempted. So from this we can
ascertain
cipher
right.
that he has answered 15 questions out of 60, attempted rather.
24.
And then Lordship, my lord, kindly comes to the last page. The marks which have been assigned to him is 8. Lordship will kindly see the ultimate page, the last one. Marks at the bottom. But my lord, what we understand is from the he has attempted 15 out of 60 and he has got 8 marks. This is what is there. And he has been shown as he has got 54 marks, which is not tallying with what is there in the OMR sheet and the answer string. So there is a 8 and 54. So
lot of difference.
Lot of difference.
Published OMR marks. Where how could the commission publish the OMR marks of the petitioner as 54 when he, according to the CBI, attempted only 16 questions?
That is why it is OMR mismatch. Therefore, Miller, that is the result. That is the OMR mismatch. He is an accused of OMR mismatch, and he is a tainted candidate. Whatever is given to us.
I understand, but then 54, one who has attempted only 16, yes.
My lord, kindly peruse the OMR sheet, because what is the OMR sheet, my lord? This is the original OMR sheet, my lord. I believe my learned friend, my lord.
No, the OMR
it will be
sheet which I have handed over to
what is the
Lordship, it
answer
is-
string, my lord? I will explain because I know it very well. My lord. What is the answer string, my lord? In just that OMR sheet.
No.
Listen, whatever you say,
Yes,
if the CBI says that it is the thing, then the court has to believe it.
My lord,
And
two
disputed
things.
questions.
Yes, my lord. Two things is that, my lord.
Tainted list.
What is answer string, my lord? That is a software. From that OMR scanning, that answer string, my lord, will evolve, my lord. That is the my understanding, and that is the fact, my lord. If the OMR sheet is not properly scanned, my lord, answer string never be arose, my lord. My lord, kindly see the other person's OMR sheet. This is a cropped OMR sheet, my lord. That might happen, my lord. The OMR sheet is somebody else, my lord. Because this is not a full OMR sheet, my lord. Kindly see
Whose
why
OMR sheet is
why
this?
why I say so, my lord. Kindly give this one, my lord. I just compare it with others, my lord. Kindly see the signature portion.
Where is the petitioner's OMR?
Yes. Kindly see the signature portion. I will compare it.
OMR can be ascertained from the
Yes.
barcode.
No.
It is the two copies
There is no
that
such
handed over.
There's a barcode, I am told. The barcode will.
No.
Yes.
Milord, what OMR, as far as whenever OMR is scanned, it goes by these which have been filled up. Now, Milord, as soon as this is scanned, it replicates in the answer script as to how many questions have been attempted, and accordingly marks are granted.
No.
Now, Milord, it cannot be a situation where only half of the OMR sheet has been scanned.
Yes.
Maybe the copy which is available with us is truncated, but
this is not his copy. Is it
this
his
is a copy signed by him and the barcode.
No, my lord, it never be. Why? Because of that, there is a 4 column. And the signature portion ended in every OMR sheet in this last portion, my lord. It never be possible to signature portion came within the 2 columns. My lord, kindly see. This is the original OMR sheet. Others, this signature portion, my signature portion is that, my lord, where it is ended, my lord, and this column, my lord, this my lord, QR code column, it is in a last portion, my lord. So QR column came, and that 2 columns goes. My lord, this kindly see this QR column. My lord, compared with each other, my lord, this QR column came, and this 2 column goes. It never be. Kindly compare it with each
Just
other.
wait. The court is trying to ascertain.
May I?
Make it affidavit, my lord. I will take
Yes.
instruction.
No.
1 minute. Yes.
Now, Milord, what my learned friend is trying to impress upon my lord is the barcode and the answer script barcode are matching. What has happened is, if this entire sheet is taken, it has been truncated from here. The signature is there, the barcode is there. Now, Milord, if my lord kindly sees it, the signature is there. This particular portion, lordship is not there. If my lord kindly takes up this.
Yes, I can understand that.
My lord now, my lord, but what happens is the entire OMR is put under the scanner at one go, and automatically whatever answers are attempted come on the sheet. Now, my lord, accordingly, that particular answer string is there, and the barcode is also in totality stated there. My lord kindly takes up the last page. That barcode matches the last 4 digits are 7755. My lord, so this particular argument being made from the bar that half the sheet has been, because half the half sheet has been scanned, that tantamounts that half of the answer string denotes that. That is not the fact. That is not the fact. If it is scanned, it will be scanned as a whole, because the system works on binary. If anything goes wrong, the system will not take it.
All right, please.
That is how computers work.
My lord, 2 things is that, my lord, my respectful submission is give this copy, but answer stick is something else, my lord.
All right, please come.
My lord allows, may I take my lord's leave?
Yes. The Deputy Solicitor General has produced before this court the truncated OMR sheet of the petitioner bearing the barcode and the barcode number along with the answer string. Stop.
They never published
The
to others.
according to the answer string, the petitioner attempted only 16 questions out of 60 questions, and he got 8 marks. Step. Learned advocate for the petitioner disputes such contention. Paragraph. Let a report by way of affidavit be prepared by the CBI and circulated to the parties. Step by, not step by 12th of December. Today is the 1st. Release the matter on 22nd of December.
Only one thing is that, my lord, last day of online application in 3rd December, my lord.
But then
abide by the result of the petition. That's if I succeed, not succeed, not succeed. But online, if I file the offline also, my lord, give that opportunity. My lord, that doesn't mean I get the.
As the name of the petitioner features in the list of tainted candidates, accordingly, no direction can be passed permitting the petitioner to fill in the application form, which is on only till 3rd December 2025. Step. In the event the petitioner is able to succeed in the writ petition, the necessary order will be passed in his favor. Necessary order will be passed, not in his favor, but passed. Yes, next.
Grateful one. Good. Extremely good.
Let 5 by 8. But here, when it kindly turns to page 30, when I joined in a school as an assistant teacher, where I worked for 6 years. Thereafter, I lost my job. Your lordship will find my approval letter, page 23. Page 23 is the district inspector of schools, Murshidabad. Now, after the judgment of the Supreme Court, I lost my job. If your lordship turns to page 30.
Yes.
Now,
we lost his job. How will you get it?
The total marks I have obtained is 56. Cutoff marks is 62. My category has been mentioned as general. Though I made a representation, but I have mentioned that I am a OBC B category. I am not a general.
What is your grievance?
The OBC marks at OBC B added marks, it has not been given to me. This is my case.
OBC B added marks mean?
But the cutoff marks, kindly have a look to page 31.
What is the cutoff in OBC B?
But that I have mentioned in detail, in page 33. Reservation of OBC as per my valid certificate, the commission has not given that benefit to me. That is my case.
What benefit?
Your lordship sees paragraph 8 once. I have mentioned in paragraph 8.
Paragraph 33 is only mentioned that update my application.
No, paragraph
categories
6 and paragraph 8 of the writ petition.
From general to OBC. And
page
33, how was it submitted? There is nothing, no proof of submission of this page 33.
This has been sent online.
Online?
Yes.
Where is the proof?
That I don't have, but I have the instruction, but this has been sent online to the commission.
The commission granted at least 3 opportunities for updating the caste category. Where are those? Did you avail the opportunity?
According to my representation at page 33.
No. Your representation will not do. You have to show something that you availed the opportunity. Otherwise, it cannot be given.
Kindly have a look.
Well, kindly look to the page 28 once.
Page 32 once.
Kindly look into page 28.
Yes, 28.
Category general.
Category general, yes.
She has written it as general.
You have mentioned yourself as general category candidate. Page 28. See?
Yes, I'm on to it.
Profile details. Then how can it be you be treated and there were options given to update? You did not. Please come. The petitioner participated in the second SLST TET 25 candidate TET 25 recruitment process, disclosing herself to be a member of the general category. The commission published at least 3 notices giving opportunity to the candidates to update their caste details. Stop. Last of such opportunity was given on 22nd September 2025. Stop. The petitioner failed to avail the said opportunity for the reasons best known to her. Stop. After publication of the final merit, after publication of the interview list, the petitioner seeks direction upon the commission to treat her as OBC B category candidate. Stop. Such prayer of the petitioner cannot be allowed. Stop. The commission has already treated the petitioner as a general category candidate as per her disclosure in the application form. Stop. Had the petitioner applied in response to the notices published by the commission for updating the caste details, her prayer for updating her caste category could have been redressed by the authority. Stop. There is nothing on record to suggest that the petitioner approached the commission for upgrading her caste category. Stop. Next, in view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Next.
Let 6, where page 20 is my letter of approval issued by the District Inspector of Schools, Purva Bardhaman. Number if your lordship kindly turns to page 3030, where the experience score
is 0.
0, educational qualification score is 0. But I worked for 6 years. I'm a SC candidate, I made 2 representations, page 31 and 32.
You are SC candidate?
Yes.
And you have been treated as SC?
Yes.
All right. You only want the marks on account of prior teaching experience. Yes, please, the commission.
In this case, when she was filling up the form in 910, she had disclosed her experience. So for 11-12 is concerned, she did not disclose. Kindly come to page 26.
Well, at 11-12, Balod will find at page 26.
11-12, she has page 26.
Yes, 910 is at page 27.
How come you have filled up page 27 giving your experience and not page 26 without any experience? If you do not disclose your own experiences, the commission go and hunt as to who has got the experience. It is impossible.
At page 29.
My lord, your lordship has been pleased to pass an order on
9th August,
November 2025.
Yes, page 28. What is
29?
29. What is your submission?
Confirmation, and thereafter I have edited the portion on 9th August. Kindly turns to be the page 29 top.
No, editing the portion regarding only the caste. Other details, could it be edited?
Yes.
So it will be open for experience details from 5th August to 11th. Where is the document to show that you... Page 29.
28, kindly have a look to the notice.
Yes, 28 I have seen.
Yes.
This is 1st August. When did you edit?
Well, at 1st August, I edited on 9th August. No, 29.
Edited on 9th August and time was till 11th. Mr. Bandyopadhyay, page 28 is a notice for updating the experience details, which the
Well,
petitioner claims to have done in page 29 within the time.
well, this is the letter he has annexed, but this is not really edited.
This is not edited.
No. But if required, my lord, I will again check up and I will come
Please
back
check
to
up.
a lot.
All right, please check up.
I will again check up, my lord, page 29.
All right, please come.
Again, I will check up and I will.
The petitioner participated in the second SLST 2025
My lord,
recruitment
this is,
process.
my lord, excuse me, page 29 is an email. This is not a form of edition, editing of.
No. This is my representation.
OTP for edit confirmation is such and such, valid for 5 minutes. Page 29, it is
Well,
mentioned.
I will check it. Give me time.
Yes,
I will
please
check.
check up.
I will check it up and I will come.
কি বললাম?
Page 29 the instruction.
Right. She claims mark on account of her prior teaching experience. Stuff. It has been submitted that she submitted the form for editing editing her experience details in terms of the notice published by the Commission on 1st August 2025. Stop. Reliance has been placed on page 29 of the writ petition in support of such submission. Stop paragraph. The learned counsel for the Commission seeks time to revert with instruction. Stop. Release turn. When do I keep it?
Kindly keep it, please. Kindly keep it on.
Today is Monday, first.
Fourth.
Thursday, 4th. Yes. এটা ফেরত দিয়ে দিন। Yes.
7 minute. Here also, while it comes to page 31, minute I made a detailed representation on 18th of November. The result regarding
Representation
910.
for what? Experience code. This is also experience.
Yes, but this is 910.
910. You served in a deputation vacancy. Not
Deputation vacancy.
Not in a regular post or something.
Well, at page 23, have a look. Yes, is my I am Shudipto.
You are
Sir, my appointment has been approved against the deputation vacancy, but I am an approved teacher. On deputation, I have been sent to a different school.
All right. And from 2013 you are working?
Yes.
Valid up to 15/5/24 or until the teacher joins, whichever is earlier.
My initial.
And you are working still now?
No, I have lost my job.
You've lost your job.
Page 19 is
No,
my
but
initial.
then if your date of appointment is 2013, how could you lost your job? Did you participate in the 2016 recruitment process also?
But yes. 2016 recruitment also.
Why don't you revert to your earlier job?
But may I take a short adjournment for this matter? But I have not been posted with the facts.
Because there is
Absolutely, your lordship is absolutely right. Absolutely, I have the option to go back. But may I only one day accommodation tomorrow? May I come back?
Bro, only kindly see the page 30. Page 30.
Yes, page 30.
Yes, it is his application. Kindly see the first Horiwar High School, 10th August 2010 to 15 May 2011. Not completed. Fragmentation is there. Then Odolbari High School, 2nd December 2023 to 13 May 2014, fragment service. Then Kebolpara High School, 1st March 2017 to 30th June 2017 and 1st September 2017.
Petitioner, please see whether you'll proceed. You've got only 30 months teaching experience, it says. Your letter.
May I come back tomorrow?
If there is a chance of repatriation.
Understood. May I sit with my advocate to court? I was not posted with the facts.
Please come. The petitioner participated in the second SLST, 2025 recruitment process, and he seeks marks on account of his prior teaching experience. Stop. From the document annexed at page 23 of the writ petition, it appears that the date of appointment of the petitioner is 2nd December 2013. Stop. The petitioner claims to have lost his job due to the order passed by the Honorable Supreme Court in the 2016 recruitment process. Stop. Paragraph. Learned advocate for the petitioner seeks time to revert with instruction as to whether the petitioner seeks to proceed with the writ petition or would prefer repatriation to his earlier place in accordance with the leave granted by the Honorable Supreme Court. Lot of questions, whether you were there in the 2016 process or not, and everything.
I've gone through the mind of the court.
When do you want to come back?
Tomorrow, they are.
No, tomorrow it cannot be done.
Fourth.
All right, 4th.
Great.
Well, in item 8, I have an application for addition of party. The only difference is here, this is for non-teaching. Similar, virus challenge.
Virus challenge, but apart from that, my lord, the selection process, the online application form is going on, my lord. This matter relating to, my lord, Group C, D, non-teaching staff, my lord. I have twofold prayer. First, my lord, they plotted the advertisement. It will be kind enough, my lord, go through the advertisement. Page 62. Sorry.
Page
62.
62. Yes.
May I read, my lord?
Yes.
Second, third, fourth, fifth paragraph. Because for curtailment of the time. Eligible candidate with the minimum qualification may apply online only and by no other mode through the official website of West Bengal Central School Service Commission. That is, their website is mentioned. Now in bold, very pertinent. It is clarified that candidates, the word is very pertinent, who have been identified as, within quote, tainted candidates in terms of judgment and order dated 3rd April 2025 in civil appeal number 4800 of 2024 will not be eligible to apply. Now kindly see, my lord, the judgment which is annexed with my writ petition, page number 68. Specifically, para 25 onwards, page number 96. The judgment starts from page number 68, para 25.
Page number 68, the judgment starts, and you want.
And relevant, which I want to show, my lord, that is page number 96, para 25.
96. Yes.
In the written submission filed on behalf of our WB Ssc in this court, two tables have been furnished. Table 1 pertains to candidate who either jumped rank or were appointed despite not being in panel. Their details are as under. Now, my lord, Group CD, these two categories, rank jump category 132 for Group C, and Group D, rank jump category 237. This is given by the WB Ssc. Now, out of panel but still appointed, 249 for Group C and 371 for Group D. in summation 381 for group C, and in summation group D 8606. Now kindly come very next table, table 2. Category A. In group C and group D category, my lord, kindly see the in bold portion, number of candidates, again candidates, with alleged OMR score mismatch as per CBI image. How many? For group C, 3,481. And for group D, 2,823. If I add these two tables, the number came out, because if I add that group C and group D, that rank jump out of panel and this OMR mismatch, the figures came out 7,293. But after filing this writ petition, the West Bengal Central School Service Commission published the tentative list of group CD candidates. Kindly see this list, my lord. Because this is a bulky one, first 4 page and last page, I, my lord, submitted
3,512.
My lord, kindly see what is the judgment, what is their advertisement, and the
What is the addition you said?
my lord, kindly see group C, group D, rank jump category 132, out of panel 249, comes out 381. So 381 plus 608 plus 3481 plus 2823. So it came out 7,293. They only published 3,512 candidates. So other candidate, they wants to again corrupt this selection process. They says out of that, whosoever got appointment, they only feature that, and that too without giving any details. Under which category, who are they? Nothing. My lord, you remember in 9, 10, 11, 12, my lord, same thing happened, and not only that, my lord. There are several categorical, my lord, tainted. One is rank jump, another one is OMR sheet, another one is out of panel, another one is expiry of the panel. So which category they fall this tainted category candidate, that is not mentioned, my lord. And I have specific prayer, my lord. Furnish whosoever the candidates who are tainted, who are not specifically tainted. And not only that, my lord, regarding OMR division major, there is a specific direction by this court, my lord, in para 363 sub para 3. Publish the OMR sheet in pursuant. Copy the. আমাকে না সব কপি দিয়ে দাও, সব কপি দিয়ে দাও, সব কপি দিয়ে দাও। OMR sheet 363 sub-para 3 for public viewing. They not published it intentionally, and the apex court, my lord, uphold that judgment. I will place that para also, the conclusion portion, para 45.
And this direction is in respect of teaching, non-teaching,
all. For selection process. They not even published that 2016 OMR sheet. They published by cutting that candidate. Because of that, my lord, what happened? Suppose, my lord, there is a dealings, 10 lakhs. Out of 10 lakhs, 5 lakhs was paid. So waitlisted is there, but not get appointment. And not only that, one interesting fact is that, my lord, kindly see, this kindly compare these two tables, para 24 and para 25. The total recommended candidate by WB Ssc in group C category 2,037, and the OMR mismatch itself in group C category 3,481. In group D 3,880 is the recommended candidate, 2,823 is the OMR mismatch alone. So in group C category, whatever the candidate recommended, but OMR mismatch is higher in number, but they again fill up the form in this present recruitment process, and they specifically barred it. But who are that barring candidate? They never disclose it. And another thing is that, my lord, 5 marks, the experience marks is challenged. The same way, my lord, I adopt the submission which is in Bhim Sarkar matter and Lubana, my lord. That's my, so, my lord, my respective submission in this as an interim measure, my lord, 2 things, because otherwise this selection process is also be corrupt, my lord. One thing, publish the tainted candidates list with all details. Number one. Number two is that in pursuance of court order, my lord, publish the OMR sheet for public viewing. Because of that, very recently, they published another notification. They says, because they want to do this matter in transparent way, they says whosoever wants to give information regarding tainted candidate, they can contact with advocate on record. That is their notification regarding publication of 269 candidates because of in pursuance of my lord's order, which is upheld by the apex court. If I wants to, any citizen wants to indicate a tainted candidate, then they ought to, given the any instances, how could he, the citizen will gather it, or any candidates will gather it if
All right,
OMR sheet is
follow
not
it.
published?
All right.
Categories.
For the addition of party,
Who are you?
the other cases, here there is, I am falling within the category of no controversy. In a sense, I am completely untainted, and also there is a controversy which is being decided by your lordship whether after panel expiry they also come
Within the category of tainted candidate
In
on.
this case, I am
It
appealing
is not
even
so.
not for that. But all I pray is that following your lordship's order, it may have a cascading effect that I want to be added as a party.
Yes, yes, addition is all right.
And on the point of tainted, whether the panel expiry or not, I have one request, not because I'm appearing as this matter, because this will have a direct impact on the other matter lordship is hearing. So I would be humbly requesting your lordship that once for all, whether panel expiry is really tainted, if they are tainted, one way, lordship may decide in that way, because suddenly if lordship decide as if they are tainted, then this submission is not valid for the applicants in this matter.
No, no.
But
Right now, the initial interim prayer that he is seeking is to publish the list of
Clear.
the candidates. So,
my lord, and
Supreme
not
Court
only
has
that,
directed, this court has directed, let it be done.
my lord, and
Then I'll
one thing is that, my lord, this matter, my lord, is regarding group
non-teaching.
non-teaching staff, my lord. The more candidate, that is OMR sheet mismatch, that is not only expiry of the panel. So it is evident from the WB Ssc's evidence itself, report itself, because it is quoted in the judgment itself.
Yes.
So they want to give opportunity to those candidates
right.
who would not get a
All right.
appointment.
Yes,
And
Mr.
category-
Bandyopadhyay.
But then his whole petition is only restricted to OMR, not for any other things.
No, other things are
Tainted
there.
and not prohibited.
Immediately, the what is troubling the petitioner is that day after tomorrow is the date, last date for filling in the application form, and the Supreme Court has reminded this court to ensure that no tainted candidate slips in. This is exactly the wordings of the Supreme Court's order.
Correct.
Now, page 96 of the judgment of the Supreme Court in the earlier matter, 3rd of April, that has been placed, where you have made a panel, table, in fact, 2 tables. One in respect of the table 1, either rank jumped and everything, and the others, OMR mismatch, and out of B who have been appointed. Right. So why don't you publish the details of these candidates as per the court's order?
But there was no court's order earlier. The division bench, which has been paragraph, which has been placed to your lordships, that I will place it, but Supreme Court has not passed that order. And this point was raised before the in a contempt application before the division bench presided by Justice Basa. In the contempt application judgment, the division bench said that order has been merged with the final order of the Supreme Court. Therefore, the contention or submission that the directions of the division bench to publish all that OMRs, etc., that is no longer there.
Sir, this submission of yours was considered by this bench on the last occasion, and direction was passed for publication of the panel, including the details of the candidates. And possibly this was there before the Supreme Court also, right? And the Supreme Court has passed order.
Yes.
to ensure that none of the tainted
Correct,
candidates.
correct. I am not disagreeing that.
So
I am not
please
disagreeing.
disclose the list.
I am not with that. I am not disagreeing. The submissions of the petitioners, the division bench order directing the OMR, all the OMRs have to be disclosed. That is no longer there. That I am submitting.
And my lord, in
My lord,
the
in that
advertisement
case, kindly
itself,
excuse me, my
they
lord,
mention in bold letter. They mention WBSSC mention. Kindly see page number 62.
my lord,
They
can
mention
I make
that
my
can
submission finish?
Yes, yes, 1
Otherwise,
minute.
can I
Yes,
make
Mr.
my submission
Bandyopadhyay.
finish? Yes. Then, my lord, in that case, if your lordship directs to disclose, we have, my lord, there's no, we will disclose because we are maintaining extremely transparent system.
Yes, please do
There may be, my lord,
and disclose.
only one thing kindly that on the other day also later I mentioned that, my lord, only to the 16 part by part, my lord, I have to do it. I cannot do it at a time.
No,
Otherwise,
but then this is the last day of filling up
my lord,
the
last
form. It's day after
matter is
tomorrow.
pending. My lord,
Matter is pending.
matter is pending. If anybody in the tainted list, his candidature will be
Will be
cancelled.
cancelled. Very well.
Yes, but give me that, my lord, that space, my lord, oxygen, so that I can part I can do it.
Yes.
Otherwise, it is cacked.
Lordship has been pleased to grant me leave. I am challenging that particular list. One order of the Honorable Division Bench of this court has not been brought to your Lordship's notice with regard to which defines who will be the tainted candidates. My contention, today your Lordship has granted me leave, so Lordship passes any orders after hearing that will be my.
Listen, the division bench of this court.
Yes, division
No, but then the Supreme Court order, I understand, is the final thing.
Supreme Court has upheld the order passed by the division bench presided over by the Honorable Justice Devanshu Basa.
No, thereafter, last week.
May I hand it over?
Implementation of the order passed in Boishagi. First,
Yes.
Without
now,
uninfluenced.
that order has been in that matter, my lord, the division bench order has been upheld. Subsequently, also there is an order passed by the Honorable Division Bench by the presided over by the Honorable Justice Shomen.
Whoever presides.
Yes, subsequent order which specifies who will be the three categories of tainted candidates. The list that they have published, my lord,
I have the issue is right now only for publication.
I'm
This
challenging that list.
This list of
3,512.
3,512 candidates
Yes,
non-teaching.
I'm challenging this list, my lord.
He is also challenging this list.
I'm also challenging.
No, he is challenging on a different footing that this list doesn't include the other.
That is separate
This is an
expedition.
incomplete list. This is his submission.
Is that this list is erroneous in view of the.
My lord, with your lordship's leave, my lord, can I just leave for
All
few
right,
minutes?
all right,
My lord.
all right.
My lord, my contention is that this list is erroneous in view of the fact that it has taken into account the other categories also, which has been clarified by the Honorable Division Bench subsequently.
Later on, I'll see.
Yes.
But then your matter will also be considered. Not that
Yes. That is my.
it will not be considered. It will be considered. Acha.
Tomorrow the matter is there, my lord. Lordship has been pleased to grant me.
Very well. The commission is here. They will come ready.
Lordship may kindly.
Acha.
There is an observation of the Supreme Court also in the 29th August order.
Yes, please read out because this compilation is coming to me in each and every
Yes.
matter, and my
26 November.
records are going up.
26 November.
Yes.
Then August which says it further states that
this matters.
if any tainted candidate slips through the net
Yes.
and manages to appear in the test,
Advocate on record.
the notice dated so and so issued by the commission stating eligibility, ineligibility of candidates would be examined in the post-examination stage, would come to the aid of the commission in weeding out the
This
tainted.
is what Mr. Bandyopadhyay
So-
said. Assuming that somebody slips, it can always
It
be
can
verified and
always
the
be
candidature
rectified.
cancelled.
But they consciously, in this matter, they consciously not given that details who are not get appointment because
All right.
untainted tainted
right.
candidates and tainted appointees is a different.
Matter relates to the recruitment process conducted by the West Bengal Central Civil Service Commission
Something is for the YouTube also.
in respect of Group C and Group D posts.
Instead
Within
of
bracket,
so
non-teaching.
instead of Group C, it could be Clerk and Group D. only.
Acha, clerk and group D.
Because we although says is Group C, but at least.
Non-teaching staff. ঠিক আছে? Reference has been made to the judgment passed by the Honorable Supreme Court in the matter of Boishaki Bhattacharya within bracket State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee. It's 3rd April 2025 order. Judgment. ঠিক আছে? Wherein the court observed that none of the tainted candidates can be permitted to appear in the fresh recruitment process to be conducted by the commission. Stop. In response thereto, a list of tainted candidates in connection with 3rd RLST within bracket NT within bracket non-teaching staff, 2016 examination has been published by the commission. Stop. According to the petitioners, how many? One petitioner or many?
No, petitioners. Madam.
Petitioners.
Five petitioners.
The list is an incomplete one. Stop. The paragraph 25 of the judgment of the Honorable Supreme Court has been placed in support of the submission that at least 7293 candidates in total have been found to be tainted ones whose names ought to be published by the commission.
With full details in public domain.
Stop. The list published by the commission contains names of only 3512 candidates. ঠিক আছে? Prayer has been made to direct the commission to publish the entire list of 7293 candidates along with their full details. Stop. Next. Learned Counsel for the Commission submits that the order of the Supreme Court will be complied with. Stop. The list of the candidates will be published. Stop. Next. The commission, no, paragraph 3. The recruitment rules pursuant to which the recruitment for the non-teaching staff will be held is also under challenge. Stop. Day after tomorrow being the last date for filling up the application forms, the court is not interfering with the matter at this stage. Stop. As an interim measure, the commission is directed to publish list of all candidates
This order kindly passes after hearing.
candidates who have been found to have rank jumped, who are out of panel but still appointed, candidates with OMR mismatch
And expiry panel.
No, expiry panel lordship is deciding. because
and
other matters will be affected.
For the time being, this category is enough.
bas,
And the expiry panel kept it open, produce it. In other matter,
That is to be.
সেটা 9-10. 9-10 in-
along with the names of the candidates, their roll numbers, their father's name,
Kindly hear
comma,
passing this.
their
We will be stigmatized.
their
for my
father's name, the details of their appointment for public viewing. Stop. The commission would be obliged to upload the details of such candidates in terms of the order passed by the Supreme Court, wherein the court specifically directed that none of the tainted candidates should slip in the recruitment process.
Placed in
Stop. The commission ought to ensure that the recruitment process remains absolutely transparent, free, and fair. Stop. The candidates whose names may have appeared in the list of tainted candidates will not be permitted to take part in the selection process.
My prayer is that this is erroneously done. Lordship is giving publication orders
That
for
is
publication.
division bench judge.
Publication is all right, but if it is erroneous, then the court can look into it.
So apex code is that
Yes.
put placed in the public
This
domain.
is the Supreme Court's order, sir.
That is the Supreme Court judgment.
It has not been specified by the Supreme Court. The category which of tainted candidates has been specified by the Honorable Justice Boschak's order,
Careful.
which has been subsequently interpreted. The mismatch category's entirety will not come. Kindly hears me on this.
I'll hear you tomorrow. Tomorrow, the matter is there. The commission is not aware of your matter. You will serve copy only.
If your Lordship kindly passes this order today, my lord, if tomorrow, if your Lordship is of view that my contention is right,
right.
then, my lord, this my lord, order, my lord, then
No, already they already published.
No, they have
3,512 candidate already published.
That is my contention.
Less candidate published. So erroneous published. If that is erroneously published, already published.
1 minute.
He should not raise
1
his
minute.
voice. If he raises his voice,
1
I can
minute.
raise my voice 5 times that, my lord. He should not raise.
Is this the place?
No, my lord, that is what he is.
There is no competition.
Raising the voice. This is not right.
There is no competition as to who went to raise the voice louder.
Kindly, I'm making my submission very
So,
correctly for my client.
right. If the if your name is already there, it is there. I'm here. I'll hear it.
Passing order for publishing my father's name, my category, and everything.
Yes.
Now, if that Lordship is aware,
Yes.
it's a huge proposal
Right.
for life.
Right.
So before that, my lord, I am praying for Lordship kindly hears me. If your Lordship is of the view that my condition is erroneous, let us say, of course. But there is a division bench order which specifies which is a tainted category, which is clarified. That has to be followed by the commission. It is binding upon all. The order passed
I'll
by-
hear you. I'm going to hear you tomorrow. Do not
But
worry.
by this time, my lord, if your Lordship kindly, my lord, gives this order tomorrow, my lord, Lordship passes this order tomorrow.
All right.
After hearing me, my lord, I'll be very much obliged.
And you are
Yes, I don't have.
participating in the recruitment process.
Because I am in the tainted list.
Yes.
I have been barred. In the advertisement itself, it is there that persons will be tainted. I have been barred. Since my name is there, I will be barred. I will not be able to participate. But further publication of father's name, the category, that will be prejudicing. So therefore, kindly hear me. But persons whose names are published are not before Lordship in none of the
But then
I am only
the
representing that category.
I understand that means
Mismatch or something, whatever they are saying.
tomorrow yours is the OMR mismatch. Next day it will be somebody else's. The groups that have been found expiry. Then Mr. Dhar is there. Expiry panel.
Expiry panel is there. Order by the Honorable Justice. His Lordship has pleased to make three points. First is the persons who are the tainted candidates. Persons who have submitted blank OMRs, that will be 20 or 21 in number in accordance with CBI. Second is the persons who have rank jump and the persons who are expiry panel.
This is the three category. Lordship, kindly do not enter into now.
It is there. It is there.
My lord, may I, may I,
Because you are tainted, you cannot.
Yes.
You cannot deal me.
No, so let it
That is
remain.
a completely different thing.
Tomorrow, let us see.
my lord, I just, my lord,
Tomorrow.
another prayer and another thing, my lord, because of the apex court, recent apex court order, I just read 3 lines, my lord. The High Court shall also ensure that the list of tainted candidate is placed in the public domain
Yes, yes.
with full details so as
Right.
to ensure that this does not happen. So that is the apex court.
Yes, give that also. It
My lord, kindly see that is the specific direction.
যেখানে বললাম লাস্টের দিকে না সুপ্রিম কোর্টস অর্ডার টু এনশিওর দ্যাট নো টেন্টেড ক্যান্ডিডেট স্লিপস থ্রু
29th August.
তা হচ্ছে ডেট হচ্ছে
26 November 2025. Oh, এটা last order. Last order.
তাতে শুধু নাম আছে আর রোল নাম্বার আছে। নাম আছে রোল নাম্বার। ফর এক্সাম্পল
রোল নাম্বার দিয়ে তো কমিশন চেক করে দিতে পারবে কি?
না ওরা
In Vivek Paria matters. Vivek Paria corrected matter.
ডেট ইজ 26th of November 2025 সুপ্রিম কোর্টের অর্ডারটা
এটা তো
ঠিক আছে ইন দ্য ম্যাটার অফ বলে এটা লিখে দেবেন বিবেক পারিয়া
This is the order for which now Lordship has to take the entire.
ওই মামলাটা কোথায় ছিল যে এক্ষুনি হলো
ঠিক আছে
My
applications will be allowed
My lord,
applications
my lord, another, my lord,
Can one may be allowed and just like
whose is can too yes দুটো can allow হবে
and we shall use an affidavit in
yes
opposition
yes
exactly
yes
in the
yes
same
yes
my lord,
My lord, names will be published.
এই যে 3 number applications have been filed seeking addition any order passed department directed of opposition reply এটা list for further consideration on
my lord, in the meanwhile,
6th January 2026
my lord, expiry panel may be produced because expiry panel, because of that, my lord, that category is not mentioned. 3 categories mentioned. That is rank jump, not in the list, and OMR sheet. And expiry panel,
That is not there. Only one thing
My
that
lord.
Mr. Lahiri is submitting, my lord, that has already been rejected by the division.
No, it has not been.
My lord, I handed over, my lord. I handed over, my lord. This is the list given by the this notification is given by the SSC in 4th category, that is 9, 10, 11, 12, Group C and Group D. When the counseling was conducted and when the panel is expired. So according to this SSC's notification itself, my lord, there are several counseling held after expiry of the panel. That the expiry panel may be produced in this category also, Group C and Group D. Because my learned friend says it produced in other matter. Already my lord passed that order. It produced. So expiry panel might be produced in the next day.
This I am not controlling an issue. Exactly should be produced. Thereafter pass the direction.
it is not a matter of judges seeing it is a matter of others seeing others seeing the court will see it is the commission who has all records
Here that will assist your lordship.
next হচ্ছে লিখুন তো যে as regards the candidates who were given appointment after expiry of the panel comma their details shall be produced before this court on the next date of hearing
কবে রাখলো
tomorrow your matter will appear give a copy to the commission let them come prepared এটা 6 January আসবে
My lord, may I return back the division bench?
yes
Division, the bulky one. The bulky one.
মোটাটা
একদম নেই।
হ্যাঁ নিচেরটা ফেরত দিয়ে দিন
Because each and every matter it.
yes each and every matter it is required
If my lord wants, keep it.
no I have it
All in him Sarkar.
Already marked.
each matter I'm marking it separately there are so many heads so many grievances everybody is separately marked
Just to prepare a compilation for your lordship.
9
আমাদের নয়
Milord, only one request, Milord. 9 to 19, I'm told, are different matters, and the virus matter starts from 20. Milord, I am to address your lordship today, but my difficulty is, Milord, another virus matter, Milord, I am.
no because the other petitioners will address the court today The writ petitioners Mr. Bhattacharya has addressed. There are others also, a few. They would also like to address the
Very
court.
good, very good.
Thereafter, you can come. In the meantime, I can hear the commissioner, whoever is available.
But may I say this, Miller?
I have one.
He has some additional party or
Yes,
something.
whoever,
Lordship has heard the freshers.
Yes.
Who are basically the private persons. Though we are appointed, we also have lots of grievance against the School Service Commission for their institutional failure. So I have this prayer before your lordships. Lordship has heard the freshers. There are some others, they will make such submissions.
I'll hear you also.
Thereafter, if lordship take up the neutral party, that state and the SSC.
So you don't want to be heard?
I want to be heard. All
Later
I
on.
say, once the freshers complete,
yes.
Thereafter, who were in service, like
right,
whom I am representing,
yes.
kindly hear us. So
yes. So
I'm also for untainted
yes
service
right.
candidates.
I'll hear you.
Yes, if you are
Thereafter,
hear us.
you and then the reply.
Thereafter, neutral party is the state.
Yes.
but could I?
You'll be there. You are the respondent.
For both of us.
Because the respondents,
We have
are
frankly
the
been
private
wronged by the
parties.
commission.
Yes.
And the way they
have lots
conducted
of
this
funds.
exam.
Miller, could
Yes,
I make this prayer? But your lordship hears, my lord, all the petitioners today. Yes, subject to Miller.
yes,
Kindly not take me amiss. Kindly not take me amiss. Here's all the petitioners today by the first half, if possible. Keep for me tomorrow, whichever time. It may be in the first half, it may be in the second half. I think one half will be sufficient for me. One half. And then here's Miller the SSC.
Well, that is fair enough.
Because since Miller, I am.
Your rule.
Yes, it's my rule.
All right.
So once the freshers finish, then lordship can hear our grievance.
Yes,
and
my lord.
thereafter,
Only
it's not that, my lord, we suffered because of the school service commissions. We are not serving on the same boat.
only one thing, my lord, in Group C, Group D, but I do not follow it because of that, my lord, because the selection process is going on. My lord, kindly record that,
Any
abide
specific-
abide by the result of the repetition. Otherwise, my lord, matter.
My lady,
Yes.
please imagine.
Shall abide by the result
Of
of
the
Please
repetition.
imagine our
My lord,
students.
another thing is that
We have to teach. We have to fulfill all kinds of other obligations that teachers have, election duty, so on and so forth. And we had to take the exam that we cleared honestly the first time around, 6 years later, second time around, because of the negligence of the commission and the state. Frankly, my lady. Frankly.
I'll hear you.
Yes, ma'am.
and my lord, there is a petition of two categories. One is freshers, and another is that, my lord, 2016 deprived waitlisted candidates. So there is two category, my lord. in the petition.
Yes, after freshers, after wait list.
তুমি কি আটটা বলছো না 20 নম্বরটা বলছো?
Who got the job
8
and
নম্বর
lost.
না 20 নম্বর কোনটা বলছো?
I'll hear everybody. Whoever has any submission, the court will hear. And the 31st is the date.
Correct.
But then since the court is hearing,
Yes.
Because Rule 19 is there, which says that if subsequently found that recommendations have been wrongly made, misrepresentation, unqualified, the commission has the
For
liberty
cancellation.
cancel. That is there. So these interim observations may not be required. May not-
for the satisfaction of certain is required. So let it remain.
With request of respect, my lord, Rule 19, when the rule itself is intra-virus, rule is under challenge. So Rule 19 is a no application.
You all come prepared because the 18 has submitted that 25 rule. If it goes 19 comes, then 16, where
Yes,
you all
yes, yes.
be. So be prepared.
And my lady, on the issue of the 10 mark,
My lord,
will
only
my lady hear that today? Or will my lady hear that tomorrow? Just
It is going on.
yes. So you'll hear us on that issue as well. Today.
Only one thing, my lord,
Very good.
tomorrow Mr. Bhattacharya
You
will not.
challenging the rule. You are
Yes, my lady. I am
You are also
not. I am not challenging the rule. I am only.
Bhattacharya will not be available. Prefix matter, because
when everybody is
no,
available, the court will hear.
on
then
third, my lord, made with third, because
Because I have already given time for filing opposition also.
Yes.
yes, they are preparing opposition.
And I have
They are
to
preparing.
come down, my lady, from Delhi for this. So I would like to argue physically.
Right,
I
right.
mean, my lady, imagine.
Petition has been affirmed today itself.
So let things be in order. I know
Yes.
this take time. This is not
Yes.
something which can
Yes,
be
yes,
done
yes.
overnight.
That-
Yes.
It will take time. Yes, exchange it. In the meantime, let submissions come because
Yes.
whatever you are submitting will be there in the opposition. I'll accommodate. Do not worry.
from 10:30 on Wednesday.
Yes.
Convenience of all.
I'll finish everything. My lady, may I be allowed to argue between today and tomorrow whenever you can accommodate me?
Let me see.
Please, I'd be grateful
keep it
for
in
that.
mind.
There is a
I'll keep it in mind. Let
yes,
me
there's a
continue.
constitution bench in Supreme Court, my lady.
Item 8.
9.
Oh, 9.
So, my lord, maybe it on third.
Item 9 is going.
Oh, grateful.
I have for the petitioner, Your Lordship.
Of the state respondents.
In this matter, the petitioner has challenged the non-disbursal of salary of January and February of the year 2020, Your Lordship, and has prayed for 10 years service benefit.
10 years service benefit.
Service benefit.
Section for
Filing and report.
Yes.
The-
You are for this.
For the state.
All right.
The
What does your report say? Dekho report ta?
report.
What does your report say? Did you
there-
serve copy?
No, I'm serving.
How will
There
you
was
know?
a area. There was a area he was paying for area salary for a particular 2-3 months. That has already been done. At the time of affirming the affidavit, that was not paid. But I have specific instruction that has already been disbursed as well.
It has been disbursed.
And with regard to the 10 years increment,
Serviceman.
that, Your Lordship, I have specifically stated that a hearing took place and the school authority specifically stated that the petitioner was required to submit certain documents, which I do not know has been done or not, because ultimately it
Has
has
the
to be-
petitioner been informed about the documents that he has submitted?
I have no document not yet submitted.
Not submitted. Why is the petitioner not submitting documents?
Can I get a copy of the
The
letter?
last letter. I've
Sir,
All right.
letter copy.
Please come.
Sure, sure. I'll be paying for
Report by
certain interest.
Report by the Assistant Inspector of Schools, Secondary Education, Howrah. Filed in court today is taken on record. Stop. Let copy of the same be circulated. Stop. According to the school, the petitioner is required to certain documents for the purpose of disbursal of his 10 years service benefit. The documents required to be submitted has been handed over by the learned advocate representing the school to the learned advocate representing the petitioner. Stop. The petitioner shall do the needful stuff with regard to the report of the ASI, Assistant Inspector of Schools. It will be open for the petitioner to file an exception to the same. Stop. Release the matter for further consideration on 5th January 2026.
Lordship, a copy of the letters may be handed.
Yes, he'll hand over. Please give a copy to him. What is this report?
Well, this is in respect of item number 10.
Wait, at 10. This is 9. This is item 9.
9.
Yes, call 10.
Well, in this matter, I am for the state will pursuant to Lordship.
Similar matter, Your Lordship.
9th of September, my Lord, we have prepared the report and money has already been paid to the petitioner.
No instructions, Your Lordship.
No instruction.
My Lord, kindly have a look at Art 2. Page number 6, my Lord. Art 2.
Yes.
Lord, it may be stated
Legal claim.
on
This has
12th
gone
of
from the ADA to the DI. Right.
my Lord, the same being forwarded to for the provisional taking
Thereafter,
on 12th November, it has been sent to the my Lord, treasury, my Lord, on that very day, my Lord.
how do you know it's gone to the treasury? It has gone to the DI.
No, my Lord, when it was affirmed on that very day, my Lord, it was the instruction, my Lord, thereafter, no communication has been received.
All right. Ashun Degi. Learned advocate representing the state files a report and submits that the arrear claim of the petitioner has been released. Stop. Learned advocate for the petitioner seeks time to revert with instruction. Stop. Released on how soon?
15th, Your Lordship. 15th, my Lord has fixed another matter, similar matter.
15th.
A copy already circulated, my Lord.
Copy handed. Next.
There is a claim for 18 years service benefit also, Your Lordship. The school has not granted that.
No, that's the according to the petition. There is a only for year salary of January and February.
Nothing more. 2 months salary only.
Yes, according to the
Check up if it is only 2 months salary, then you can come back earlier. Why 15th? Today is only 1st. You come back next Monday, 8th. All right. 8 Tarikh. No use of keeping it further week later.
Next.
But in the last order, it has been recorded the 10 years.
Based on this delayed payment, Your Lordship.
First, you see whether you've received the money or not. Then the question of interest. And when did it fall due?
January 2020.
2020. All right. See whether the money has been paid. And the next one, 11.
Well, item 10 record be kept to the record.
Yes. Report is on record.
Similar matter, Your Lordship.
Similar means?
Payment of January and February 2020. And
I am respondent number 5 and 6.
Yes, what is your submission?
10 years.
Document not handed over till today.
Documents not handed
Yes,
over.
lastly circulated on 24th October 2020.
2 months salary?
2 months salary as well as 10 years service benefit.
Yes, service benefit.
So this is the copy.
A copy may be supplied.
My mistake is, I couldn't serve it.
Give it copy. What is your submission?
Sir.
Same order as 9. Same order as 9. Did you get a copy?
Yes, Your Lordship. Just no. The letter I have not yet received, Your Lordship. Copy.
What are the documents to be submitted?
We also forward this to WhatsApp group also.
To the teacher?
Yes. So annex in this copies.
Same order as 9.
What is your expression?
12.
Sorry.
Item 12. None appears on behalf of the petitioner. Dismissed for default. Acha, for the petitioner on repeated occasions. Dismissed. 13.
No, I'm for the. I've retired on 30th September 2025. Second round of litigation. I was enjoying my postgraduate scale of pay from 1985. Now, at the time of retirement, they say I'm not entitled to postgraduate scale of pay, and therefore this has to be refixed. I questioned before this honorable court. This honorable court directed that there should not be any overdrawal deductions, but they directed to consider without, because this was there they have considered. That's now I'm challenging with your lawsuits by this petition.
Where is your other side?
That's why, my lord.
Where is
I've stopped again.
impugned order?
Impugned order at page your lordships 168. I just take your lordship that how they are misleading the.
No, but then this has to be decided upon affidavits. Otherwise, no scope. Please come.
No, affidavit.
The reasoned order dated
This is a
30th
petition of
October 2023.
24.
Passed by the District Inspector of Schools within bracket Secondary Education, Paschim Medinipur.
Well, let them file a report so that I think your lordship, if you'll have placed the order, that would be the reflection in the affidavit. They say according to the government order, I do not get it. I have to satisfy your lordship that I am.
Stop. Mr. Shaurav Mitra's name is recorded as for the state.
Exactly, your lordship.
Where is
Sir,
he?
may I come back again?
No. Learned counsel for the state is not present. Stop. The legality and validity of the impugned order is to be decided upon affidavits. Stop. Let a report by way of affidavit disclosing the stand of the state be prepared and circulated by 23rd December 2025. Released the matter on 19th of January 2026. It will be open for the petitioner to file an exception to the report to be filed by the state.
Let it appear under the same
Service-
heading, my lord. Otherwise, it will take
Service-
long time, my lord.
Taken on record.
It's a pension, my lord, release matter.
But earlier matter, your lordship recorded this as identical as item number 9. But when it actually filed today, we kept the record.
It will be recorded. What is IA?
IS doesn't, my lord, it affect. Let it be pending your losses, hear it along with the application.
What is
See,
there?
my lord, the DI directed again to file the pension paper with the reduced rate. That's we have.
All right, next 14.
My lord, may I, my lord, as for order some, my lord, otherwise hearing it will be very difficult.
For orders means the court has to hear and then pass order. So I'll hear
Hearing your
you.
losses will not be possible, my lord.
I'll hear you. Without hearing, you want an order.
No, my lord, hearing and under the same heading, to be mentioned, your losses can also hear us.
Yes. If you want,
Yeah, I otherwise I would not have pressed your unless it's a pension matter.
or you mention I am upgrading pension matters. Yes, petitioner.
Lordship, in item 14, there was a direction to file report, my lord. But I
Peremptory opportunity granted to prepare and circulate the report. Give.
Lordship, we could not prepare because my lord, the selection process relates to 2011, my lord. We could not manage to get the complete details of the petitioner, my lord.
This is
Details of the petitioner.
Yes, my lord.
what details they want, milord. 2013, the first it was filed, milord.
August 25, there is a direction for filing the report.
Yes, my lord. There is one extension also, my lord, on 14th
Yes,
November, my
but
lord.
then, from August, you all didn't do anything.
Lordship, we could not manage to get the complete. This selection process relates to 2011, my lord.
What are the details that you want?
Lord, the petitioner had prayed for the original OMR of the petitioner, my lord.
Not really. But in 2013, we filed a writ petition challenging the question and answer key of the milord, that selection process, milord. That was milord, order was passed in my favor. All writ petitioners have milord, got their appointment, were milord, qualified. Now, milord, so far I am concerned, they said that the OMR is missing, and they asked me to provide the OMR that I have provided, and based on that, they are supposed to file report.
Lordship, we could not manage to get the complete.
What document do you require?
Lordship, whether the original OMR is available or not, and the assessment whether it has been done at the basis of the.
Because that is the reason. he
Whether
has
any
directed-
assessment is done on the basis of the OMR provided by the petitioner, my lord.
See, by this way, it cannot be done. What is the ultimate belief?
My lord, kindly keep it on next Monday, my lord.
In fact, the direction of the court was to give appointment. Now, my lord, only my lord, 1.5 marks short. Court has assessment. They have assessment. At least 6 question is my lord, wrong.
My lord, kindly keep it on next Monday. Whatever instruction is available, we'll put on record, my lord.
Today is Monday.
Yes, my lord.
Right, from August, you could not prepare. And you say by 1 week you'll be able to do it?
Whatever instruction is available, we will prepare it on that basis.
Instruction, there is a requirement of a report.
Yes, ma'am.
Your instruction is not sufficient. Do you have a copy of the OMR? Is it
Already given.
annexed?
Already given to them.
Is it annexed? Which page?
At page 79.
Please come. The report directed to be filed by the commission has not been filed till date. Stop. Submission of the commission is that the OMR sheet, now that all documents of the petitioner are not available. Stop. The petitioner has annexed his OMR at page 79 of the writ petition. Stop. The allegation of the petitioner is that his OMR was not properly assessed, and he was not given marks in respect of 6 questions. Stop paragraph. The commission is directed to assess the OMR of the petitioner, which is allegedly annexed at page 79 of the writ petition, and revert with a report. Stop. Let a copy of the report be circulated by 9th December. Release the matter on the 15th.
Blood.
last occasion when the matter was taken up, that I submitted a similar, same selection process. Other repetition is pending to track both the matter together.
Give the number.
ওই তো সালামুন।
Not recording an order. এটা এখানে হবে না।
Yes, ma'am. This determination. It's a group to
Determination.
Yes, yes.
Group to মামলা action দিয়ে দেবেন তো। Are you aware of this matter also?
Yes, my lord.
Are you preparing a report in this matter? The other one?
There is a direction for filing affidavit that they have not filed.
Please make it read. It has been served.
Report is done, my lord.
All right.
If
If
it is
that
done.
be so, then the next day when this matter will appear, the other one will also appear.
Grateful, my lord.
Next.
Right, number 15, I appear for the petitioner. But there was an order passed by this honorable court for service upon the state as well as the commission. But what I have gathered from my junior, my lord, that the service with regard to the commission was affected, although she is not carrying the affidavit of service. And the service of the state could not have been affected because there is a change of guard with regard to the learned advocates. They are not anymore in the panel. But I was
Please come.
praying that 1 week's time be
Let
given.
notice be served upon the learned advocate representing the state respondents. Stuff. Release the matter in the combined monthly list of January 2026.
Grateful.
All respondents to be served
Yes.
prior to the adjourned date.
Grateful.
So I am appearing for the commission led by Dr. Patel.
Yes.
Grateful, my lord.
Oh, thankful.
স্কুল কমিশনের জন্য কিন্তু নেই,
হ্যাঁ হ্যাঁ
স্কুল কমিশনের জন্য তো আমি নিয়ে কিন্তু
If matter pertains to compassionate appointment of a legal heirs of a deceased headmaster of a school. My father expired in the year 2014. My elder sister made an application. But unfortunately, she was also expired just 1 year after in the year 2015. And consequently, I made an application. My application was considered by the authority in the tribunal of rejection at page 44. Kindly sees the order passed is cryptic, unreasoned, taking into consideration of DA and MA also, and without taking the pensionary benefit, family pensionary benefit of the our family. So, my lord, kindly see page 45. Backup has been given. This backup is not in tune of the 2009 rules. And I am forfeited by a judgment of the Honorable Division Bench held in the case of considering the rule itself that DA and MA should be excluded. Otherwise, rule is redundant because at the initial point of time, Group D's salary is 11,000 something else, it is fixed. But at the age of 55 above, after getting 3 or 4 ropas, deceased employee must have been higher. If that is counted, that it is not coming within the purview of less than. If your lordship kindly take the Honorable Division Bench. এটা তুমি একটু নিয়ে না, আমি দিয়ে দিচ্ছি তোমাকে, আমি পড়ে দিই। Kindly take paragraph 3, interpretation of rule, and another Honorable Division Bench also interpreted in that way. May I read for? The rule has been quoted in paragraph 3, short judgment. On plain reading of the said rule, rule is 2009 rule, same. Computation of the income of the family provident fund gratuity 40% of the family pension of the first 7 years shall be excluded. We are not referring the other portion of the said rule as they are not relevant for the present purpose. The question arises whether dearness allowance and medical allowances can be treated as a part of the income of the family. The rule has clearly stated that if a family member has the income earned any other sources other than provident fund gratuity and 40% of the family pension, that could be taken into consideration in addition to 60% of the family pension earned by a member of the deceased family, determining the financial hardship. This rule has not
Tell
been.
me one thing.
My lord.
This impugned order is dated 24th of June 2020.
2020.
You filed the writ petition on 28th of March 2024. 4 years delay.
Yeah.
How do you explain it?
Yes, my lord, may I take? I believe another writ petition was filed due to some writ petition reasons it was withdrawn or something else, and thereafter it has been. But even then, I have challenged the impugned order of 2020. But delay, I believe.
Delay in a matter of compassionate appointment is fatal.
But
The person expired in 2014. We are at the end of 2025. 11 years already gone. Why will your case of compassionate appointment be considered?
In case of vice versa, my father expired in the year 2014. Decision has been coming 2020. They have taken a decision after Justice Nagaratta's judgment is.
So
here.
what?
They have also taken a decision.
They may have delayed, but then you cannot sleep over your rights.
But so far as beneficial legislation is concerned, subject to correction, there are a lot of judgments are there.
You want to come ready? Come ready. Please come.
My lord.
The matter relates to appointment on compassionate ground. Stop. The employee concerned expired in the year 2014. Stop. The impugned order rejecting the prayer of the petitioner is dated 24th June 2020. Stop. The instant writ petition has been filed in March 2024. Stop. There is no explanation regards the delay in approaching the court. Stop. Learned advocate for the petitioner seeks time to come prepared. Stop. In view of such submission, release the matter in the combined monthly list of January 2025. 26. Service is taken on record. Next. State, please come prepared on the next day. 17.
17, I am for the petition. But in this matter, relating to the, in this matter, in the CPF to GPF area pension interest, petitioner was filed, and then petitioner was died, my lord. And he has filed substitution application, my lord. And but my lord, after 56 days delay, my lord. My prayer kindly allow this substitution application. This is my humble prayer.
No, but then CPF to GPF
area pension interest. That matter also.
Area pension interest is pending before the division bench.
My prayer must kindly allow the substitution application.
Substitution application.
This is my humble prayer.
All right. Where is the application?
Yes, my lord.
Ajay, please come. The issue in question as to whether interest will be payable on account of delay in grant of the benefits on conversion from CPF to GPF is pending consideration before the Honorable Division Bench. Stop. During the pendency of the writ petition, the sole writ petitioner expired
13 December 2024.
On 13th December 2024. Stop. An application for restoration has been filed on 7th May 2025. So there is a delay.
56 days. Also section 5 also application file, my lord. Next application. And application can number 2, my lord.
What is the reason?
The reason is, my lord, paragraph 6, my lord.
An application for condoning the delay in filing the application for substitution has also been being satisfied with the explanation in approaching the court at a delayed point of time, the application for substitution stands allowed. Stop. The department is directed to substitute the name of the deceased petitioner with the heirs of the writ petitioner, details of whom are appearing only one. Appearing in paragraph 3, page 5 of Can 1/2025 stuff. Substitution shall be effected at the earliest, but positively by 24th December 2025. Stop. Liberty to mention the matter. After judgment/order is passed by the Honorable Division Bench. Can 1 and 2 allowed?
I'm grateful, man.
Affidavit of service is taken on record. Next.
My lord, I have stated along with belongs.
My lord, the petitioner, kindly note the date. The date is very vital. The petitioner was appointed as an assistant teacher from 12/1/1981 to 31st May 1984 in a St. Mary's School. Thereafter, he was appointed as an assistant teacher from 1st June 1984 to 13th January 1981 as a principal in the Sacred Heart School. Thereafter, he was appointed as an headmaster from 14th January 1991.
Listen, you want your pension.
Yes, sir. What happened, I told you, see, I was initially rendering service as an assistant teacher in a delegating school, in the first two school. Thereafter, from 91, I was working as an headmaster in the Danton Aided School. I was retired in 2015. Now, a pension paper has been sent by the school authority. Now, they did not take in action to grant this pension. I moved a writ petition before this honorable court. Court passed an order that you made a representation, let the representation be considered by the authority, and if any order is passed in favor of the petitioner, necessary consequential relief be given to the petitioner. Now, the DPGG passed an order, since your two schools are the delegating school, your service will not be counted as a recognizable service for getting the pension. Now, my lord, this, you also know, there are series of judgment by this honorable court that the service in respect of the delegated school will be recognizable for the purpose of getting benefit. This is the judgment, my lord. First, kindly see the judgment.
I want to copy to you.
The bottom, my lord, last the 5 law.
Which portion?
Kindly see last 3 paragraph from the bottom. As such, the government order, as you just got it.
Yes.
Dated 9th April 2006, in my considered view, has no application in the facts of the instant case, as admittedly, the petitioner initially served in a delegating school and thereafter in the aided institution wherefrom he retired. As such, the petitioner's right to get pensionary benefit, which enumerates from the government order dated 20th May 1980, cannot be denied by the state respondent. The court holds that the concerned district inspector of school misinterpreted the provision contained in the government order dated 19th April 2006 and the government order dated 8th January 2007 respectively. The impugned order is absolutely illegal and as such, the same cannot be written on record. The impugned order stands quashed. The concerned authorities are directed to count both the period of service of the petitioner in delegated school as well as in the aided school where from the petitioner retired as a recognizable service towards the pension in terms of the government order dated 20th May 1988 and the pensionary benefit including all area pensions shall be granted to the petitioner. Now, relying upon that order, now next, my lord justice, finally see this order. Yes.
Show me the order dated 30th July 2012 in WPA 3783.
Seven.
3783 2007. Order is dated 30th July.
2012.
Where is that?
What is that one?
Why? Mr. Singh, what is your submission?
My lord, I have already on the last occasion I handed over.
I have this.
Report, my lord.
You are relying upon the 19th April GO.
According to DTI, so for that's GO 136 in B, dated 15/5/1985.
Prior to that, paragraph 5. Paragraph 5.
1985.
Paragraph 5, please see 19th April 2006 GO 131.
He's not entitled to what
This has been set aside. This is the order that your learned friend is producing. Go through it and come back. This has been set aside.
Give me 2 days time, my lord. Let me
Please come.
have the instruction, man.
The petitioner was initially serving in a DA getting school, and thereafter he joined a government aided school. Stop. On his retirement, his service in the DA getting school has not been taken up for consideration for for calculating his pensionary dues.
Here, my lord, here nothing has been considered.
Yes, stop. The petitioner is aggrieved by the same. Stop. Reliance has been placed on the order dated 28th June 2012, passed in the matter of Jai Shankar Singh versus State of West Bengal and others.
In this matter, my lord, already the 19 since August 1997 to 30th September.
Judgment dated 24th August 2017 in the matter of Shilpi Bose versus State of West Bengal and others. Where from did you get this order? The WPA number is not mentioned.
Through net, I collected this order.
No, the WPA number should be there. Otherwise, he'll not get to know.
But that is not available through net.
How can it be that the WPA number is not there?
Nothing is there.
You check up, please.
Not even the signature. I mean, the person.
Signature? Whose signature?
Let him, my lord, let him serve the entirety.
No. Check up. It is there in the server, he says. What entirety?
Let me find it out. And the my lord, the thing is, my lord, see the last 2 lines. And his service from August 1997 to 30th September 2000 are already been considered an acceptable. Qualifying service and pension benefit. This is not the case that nothing has been paid. Has been considered.
What about from 81 to 97? 81 to 97, what will happen to that? To allow the learned advocate representing the state respondents to come prepared, release the matter on 5th January 2026. Combined monthly list. Service is taken on record.
Next matter, my lord, I am praying for the petition with liberty to file application. Next matter.
Why?
My last occasion, your lordship directed to file a supplementary affidavit annexing the case list of 2012 documents, madam. and also certain things which has not been included in the petition matter. That's why I wanted to withdraw the same and file to afresh on the self cause of action with better particulars.
Call 19 once. Please come. Learned advocate for the petitioner seeks leave to withdraw the instant writ petition with liberty to file fresh writ petition annexing all documents which will be relevant for effective adjudication of the instant list. Stop. Leave prayed for by the petitioner is allowed. Stop. And the instant writ petition stands dismissed as withdrawn. Stop. It will be open for the petitioner to file fresh writ petition upon proper and better particulars
On the
same cause of action.
But I'm for the state matter. I don't know that.
না শো একটা তো বেজে গেছে দুটো
Before the start, I'll take 10 minutes to add one point.
in which matter?
With SSC matter, that
The petitioners will make submission. It's not that the respondents, it's the petitioner's turn. Thereafter, additional party is there. Yes. Thereafter, I'll hear the state, the commission, and everybody. So we'll join after recess.
Good.
May I permit to mention, one correction matter it was taken up.
It has been communicated to me. The corrected copy will be uploaded.
Item number 20, we are filing our affidavit in opposition.
Served?
We have served
Just
these
now
states.
served, my lord, I have received. All right. You prepare your reply and circulate. In the meantime, submissions can continue.
21. 20 and
কোনটা?
21.
Item 20.
Your Lordship, died on behalf of the state respondent.
আমাদের 24, 27.
Copy now.
Yes.
Copy to circulate করে দাও।
But your copy appears to be a voluminous one, and the one that you are serving.
না স্টেট না আমি বলছি তুমি কি 27 সেম এফিডেভিট
ঠিক আছে।
করছো মানে ইউজ করবে
দেখি কিভাবে কি বলে। Yes. Who's going to? You're going to make submission? Item 20. You have a can.
No, I'm in 27, lad.
Then
Well, since your lordship was
Lad.
possibly when Mr. Bhattacharya
what is your? You have some addition point.
Yes,
And it will be there in 21 also.
that's why last time I've submitted that my matter will be connected with item 18. On that day.
That is
Today,
18.
today is 20.
Today's 20. All right. Commission, please take note. Item number 27. Submission is being made. This will be in relation to item 20 only.
It's 27. I also have my application and
I'll hear.
Yes.
Yes.
সেম এফিডেভিট দিচ্ছে তো খুলেছি
মোহাম্মদ নাসিজ আইপ্যাডটাকে
20, 27, whole.
তোমারটা পাঠিয়েছি তোমাকে পাঠিয়েছি বুঝছো
Yes.
সেম এফিডেভিট তুমি আমার সাথে ইউজ করছো
এই তো সমীরা সার্টিফিকেট
I'm expecting that they'll be using the same affidavit in my matter also.
All right.
I'll not take much time. Whatever Mr. Bhattacharya has submitted last occasion, Milad. In addition to that, Milad.
27 is in connection with 20 only. দেখি ফাইলটা দেখি একটু সাথে সাথে
একটা বই বার করে ওইখানে আরেকখানা বই আছে ওখানে নিয়ে নাও
এগুলোকে একটু সরিয়ে রাখো
না
হ্যাঁ
we have challenged the virus of the rules going to be added only now what already prayer first challenge to the rules
হতে পারে
না তুমি এখান থেকে নাও হেডমাস্টার্স ম্যানুয়ালটা
yes please
Now on 7th November, Milad, your Lordship's order records, Milad, my submission, Milad. The points that I have taken.
Seventh November, 12th
7th
November, I see.
No, 7th November.
7th.
Yes, 7th November.
In this matter?
Yes.
Are you sure?
Yes.
This is Rahul Mondal?
Rahul Mondal.
I don't see the order of 7th November.
তাহলে একটু দেখে দিন না 7th November অর্ডারটা সেই ফাইলে
আলাদা করে অর্ডার শিট আছে নাকি হ্যাঁ তো 7th নভেম্বরের তো অর্ডার নেই
and in fact this all points were summarized in fact
all right হ্যাঁ দেখুন তো 7th কিছু আছে কিনা yes say what is it
Yes, order was passed. I have copy of it.
Let us see. Yes. Then
the point of discrimination was taken selection of a particular teachers by the state to give this benefit of 10 marks. All this has been recorded in the 7th November order.
Yes.
But whatever Mr. Bhattacharya has covered all this point in his submission. And in addition to that, if you kindly take some School Service Commission Act once. Because we have challenged the rules. আমার বইটা কোনটা we have challenged the বইটা দিন না যাচ্ছে আমরা rule making power is not
ঠিক আছে কোথাও একটা হবে okay yes
section 17 power to
make rules yes
the first is general power state government may by notification make rules for carrying out the purpose of this act then in particular and without prejudice to the generality of the foregoing powers such rules may provide for all or any of the following matters then clause D is relevant. The manner and scope of selection of persons for appointment to the post of teachers and non-teaching staffs under section 1 of section 8. This is relevant. Now let next section is section 18. Is part 2 frame regulations. This is also important. The Central Commission may, with the previous approval of the state government, make regulation not inconsistent with the provisions of this act or the rules made thereunder for discharging the function of the commission under this act. In particular, and without prejudice to the generality of the foregoing part, such regulation may provide for all or any of the following matter: the terms and conditions of the employees of the commission, clause B of subsection 3 of section 6, and then B, procedure for conduct of business of the commission under subsection 2 of section 8. Under subsection 1 of section 8, rule making power has been given. Under subsection 2 of section 8, the regulation frame right has been given. Now let's kindly take some section 8. Before that, let's kindly take some section 7, because the conduct of the business must be in consonance with section 7.
Section 8.
7. First 7.
7.
Because commission has to function within the parameter of section 7 and 8.
Yes, 7.
Notwithstanding anything contained in any other law for the time being in force, or any contract, custom, or usage to the contrary, it shall be the duty of the Regional Commission to select person for appointment to the post of teachers and non-teaching staffs within the jurisdiction of the commission. This is the scope of this act. Then section 8, manner and scope of selection of person proceeded for conduct of business of the commission. For the purpose of selection, this section 8 will be applicable. The manner and scope of selection for appointment to the post of teachers and non-teaching staffs shall be such as may be prescribed. Then procedure for conduct of business of the commission shall be such as may be provided by the regulations. Now if you let's kindly take some now the regulations. Copy আছে কেন? Tough কেন হবে? Will your worships take up my books if it is not there? Regulations, let's got it.
No. Regulation
Of 1998.
is it not there?
Must be.
The headmaster's manual it is there. I'll find it out.
Check up.
এইটা না হেডমাস্টার্স ম্যানুয়াল ওই নতুন বইগুলো এই দাদা এটাতে দেখি এটা আমি বার করছি কিন্তু নতুন বইগুলো মাইনরের কাছে নেই
Not there in the library either.
No, it is available. New volumes have come 2025.
দেখবেন তো
there.
এসছে কিনা?
What is there? 530 এইটা না আমার এই যাচ্ছে দাও না
Yes.
There was 2-3 amendments. I believe this has been incorporated in the amended part here. Now section 3, this regulation is called this West Bengal School Service Commission procedure for selection of person for appointment to the post of teachers, including headmaster, headmistress, superintendents of senior madrasa in recognized non-government aided schools, and procedure for conduct of business of the commission regulation 1998. Now section 3, information regarding vacancies. Regulation 3. how to seek for vacancies. Then section regulation 4 advertisement. Section 5 is the application form, submission of application. Then section 7 selection of candidate. Sorry, regulation 7. Now kindly take some that clause B and C of regulation 7. Procedure for and the manner of conducting examination of the respective regional commission shall be decided by the central commission, which shall issue separate details instruction in this regard. On the basis of the result of written examination, academic score, each regional commission shall call for interview of the candidates not exceeding 2.5 times of the number of vacancies, depending upon on the number of successful candidates in the examination. Now, let section regulation 8 preparation of panel. On the basis of the result of the written examination, academic and personal test, all added together, each regional commission shall for each subject prepare final merit list. That is to say that a panel of candidates found fit for appointment strictly in order of merits. Each such panel shall include name 1.5 times of the number of vacancies if the procedure has been prescribed. Now, all that I am trying to submit that the scope is written examination, academic score, and personal test. There is no experience in not given this regulation, and this regulation is still subsisting.
No, their submission was that the academic score will contain the prior teaching experience.
That is their submission.
That is their submission.
Namlad,
your submission will be academic score would mean only the certificates and the documents that you have collected or gained, not the prior teaching experience.
Namlad, manner of selection as well as the conduct of business of the commission. Namlad, there is power to frame regulations. This regulation is existing from 1998. In fact, first 2-3 selection process was done based on this regulation only. There was no rules. Subsequently, in 2000, possibly 2004, and subsequently repealed by 2007 rules, and then 15-16 rules. Now, up to 19 rules, which nobody has referred. After 16, there was the rules of 19. Then repealing 19, this 25 rules. None of the rules refers to that academic score
includes the prior teaching experience. So you are primarily hitting on the prior teaching experience.
There is, yes. Otherwise, there will be conflict between this regulation and. Namlad, other concern was
yes.
If you kindly takes up the rules which was repealed by the present rule.
That rule was hardly came to the fore because in the meantime the
my
entire
would be in this respect that 16 rule there was selection process. But to ensure transparency in the selection process after their experience, these rules was not introduced. Now, these rules was never given effect to, rather acted upon. Now,
because no selection process could be conducted.
Only one advertisement I have seen. They have issued based on these rules.
Then what happened to that advertisement?
Nothing happened. Thereafter, these 25 rules. I'll be asking I'll be praying before this court they should produce records before the court as to why this present rule was required to be introduced, repealing these rules.
19.
Because they have done some exercise on this state executive, then there must be some reason for repealing this one and
bringing in the new one.
Whereas I'm making this submission because if you look to the 19 rules, this will not only ensure this more transparency, rather more emphasis is given on merit. Kindly look to the rules once.
Give. Yes.
That if you state comes to page 10 of the rules, schedule B, that this manner of selection, in fact, has been reduced here. 19 rule. Schedule B, the manner of selection. Kindly see, for upper primary, 150 marks for TET. For secondary, senior secondary education, physical education, work education, this preliminary test of 150 marks. This is screening test. That was there. Then main
What falls under PT? Is it mentioned anywhere in the?
Yes. Act. Left side teacher will test refers to TET, and thereafter preliminary test referred to PT.
Yes. What will fall under the preliminary test?
Oh, that possibly has not been mentioned.
Not been mentioned. Again, there is a blank.
Preliminary test must be it's a written test. If you let's say kindly take some rule 10 clause 3, commission at the time of publishing merit based panel of successful candidates equal to the number of vacancies shall arrange system information to inform each candidate through its website. Oh, this is PT marks. That's why I've said that more transparent. It was not available with me. That's the whole difficulty.
What are the heads in this preliminary? All right, they will say what is
yes, they can clarify.
there.
Now, clause 10 is very important. When clause 3, they discloses marks of PT, marks of TET. They discloses cutoff marks of PT for category. They have each candidate applies for. Then if he has qualified in TET or certificate on the date of advertisement or secured cutoff marks in the category of PT, the total marks secured by him in the main examination, each group along with final marks of the last selected in the merit based panel in respective categories, these all will be published in the website. Then again schedule B, the rest marks kindly see clause 2, main examination comprises written examination and weightage.
What is this weightage and how
Weightage
much?
is given later.
Yes.
This written examination is English composition and comprehension 100 marks. Paper for each group 50 marks. Then language on medium of instruction. Now kindly see then knowledge of the subject group in which the candidate is appearing. These are the marks. Then note candidates precedent for appearing in the written examination. This has been clarified. Then clause C, this weightage part has been clarified. Basically percentage of marks.
That means whatever you do in the examination, weightage will be given
yes.
according to that.
Yes.
Not of any prior teaching experience or anything.
Therefore, my submission up to 2019, all rules were in consonance with this regulation. Only in 2025, they have introduced this new phenomenon of teaching experience, which according to me is arbitrary and this entire conduct, if your lordship kindly takes up the dates, 2019, 29th May, rules was introduced. 30th May, advertisement was published. And on that day, vacancy was declared also by a separate notification. Therefore, entire action was taken. Before that, if your lordship looks to the orders passed up to approaching court, Supreme Court for clarification, review, etc. They were trying to protect the previous election process. Up to that level, there cannot be any option for them or scope for them, or rather occasion for them to think of introducing these rules. When they have failed in all along, only thereafter to support some of the candidates which they were doing from the beginning, these rules were introduced, rather to favor. Now, other submission would be if you say kindly takes up my prayer K. Basically, to ensure transparency in the selection process, I have made this prayer. Now,
1 minute. K is to undertake ongoing recruitment process strictly in accordance with the constitutional principles.
Since I have said that rules is violation of Article 14 and 16, so bring it in conformity and ensure transparency. Now, my submission is that if you look to the provisions of Act and the regulations, their appointment of chairman of the commission and the members and other staffs is done under this Act. Their discipline is regulated by this Act and the regulations. Now, this today this is undisputed that there was some illegality for which entire selection process was set aside. Now, those who are employed with the office, and unless they are find out, and if this subsequent selection process is done at their instance, one part is criminal, that is going on investigation. Other is for civil wrong, they have to face the disciplinary proceedings and other consequences in terms of the law. Unless that is done and the selection process is entrusted with them, same thing may recur. That's why I have made this prayer. Oh, which judgment at only one judgment I'll cite. Taken out. Which is SCC online 1009. This is 2025 SCC online SC 1009. Fact sheet at paragraph 6. The facts of the case reveal that the constable working in police department in the year 1995 were given 20% of the vacancies to compete under the direct recruitment quota, and they were to be given seniority over and above other 80% remaining constable recruited through open market. This is the facts. Now, paragraph 8, order of High Court. High Court has assigned a reason for granting seniority to in-service candidates who have taken part in the examination meant for direct recruitment under the 20% quota by holding that in-service candidates have to be given preference, especially as they are experienced people in the department and had learned the nuances in the police department. Then in consequence whereof what has happened is that just a second. Yes. Paragraph 19. Planet Council for the appellants has demonstrated before this court that the appellant Swanso has secured 79.10 marks and he was the first rank holder, and one Swanso who was a departmental candidate has secured less marks. However, a department candidate has secured, however, the Swanso has been placed over and above the person who have obtained higher marks. And in fact, all department candidates have been obtained less marks than the open category candidates under the direct recruitment quota and have been placed over and above the person who have been obtained more marks only because they are in-service candidates. Have you got it? I'm going to straightway observation of the court. This is a factual background. 27. In the present case, the direct recruitment has done 80% of the vacancies through candidates from open market and 20% of the vacancies under the direct recruitment quota from in-service candidates. The pre-amended rules of Rule 25 provides for fixation of seniority with reference to the rank assigned by the appointing authority in the select list, meaning thereby only on the basis of the marks obtained by each and every individual candidate. Therefore, this court is of the considered opinion that all seniority lists right from 1995 deserve to be recasted by assigning proper seniority to the candidates who have been appointed from the open market as well as from the in-service candidates solely on the basis of the ranks assigned to them to the selected candidates by appointing on the basis of the marks obtained by them in the examination. On the basis of which they have been selected and appointed to the post of sub-inspector of police, there is no other process which can be followed in the present case. Therefore, merit has been given preference over the seniority or any other experience being an in-service candidate. Now, my last submission is page 89 of my writ petition, the second schedule of the rules. To be judgment bar করে দেবো, ওটা just hand over করে দেবো, ওটা পড়বো না। 24 যে rules regulation judgment 2024 regulation বার করে রেখে দাও।
Yes.
This submission I had made earlier also, my lord.
Hmm.
This schedule 2 refers to selection to the post of assistant teacher class 9-10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience, oral interview, and lecture demonstration. Like this lecture demonstration basically refers to his experience and or his quality. This demonstration ultimately determine his quality of teaching. If somebody gets benefit.
So in lecture demonstration, the prior teaching experience can be ascertained. There is no requirement of having a different head of prior teaching experience.
If you give, no, they are giving different, under the different heading, they are giving marks.
Yes.
They cannot give marks twice for the same reason. For how to interpret rules, I don't need much, but this is the latest judgment. Only paragraph 37. 2024 13 SCC 241. Action will reach. Paragraph 37.
Yes.
These are my submission.
37.
37.
What does it say?
2-3, paragraph 37.3.
Yes.
If a rule is challenged as being ultra-virus on the ground that it exceeds power conferred by the Parent Act, the court must firstly determine and consider the source of power which is relatable to the rules. Secondly, it determine the meaning of the subordinate legislation itself. And finally, it must decide whether subordinate legislation is consistent with the and within the scope of power delegated. Then 37.4, delegated rule-making power in the statute generally follows a standardized pattern. A broad section grants authority with phrase like to carry out the provisions or to carry out purposes. Similar phrases has been used here also. Another subsection specifies area of delegation, often using language like without prejudice to the generality of the foregoing power. The same phrases has been used here. In determining if the impugned rule is inter-virus or ultra-virus, the scope of delegated power, the courts have applied the generality and enumeration principles. Then generality and versus enumeration principles lays down that where a statute confers particular powers without prejudice to generality of a general power already conferred, the particular powers are only illustrative of the sense, even if the impugned rule does not fall within the enumerated heads, that by itself will not determine if the rule is ultra-virus, inter-virus. It must be further examined if the impugned rule can be upheld by reference to the scope of general power. Here, I have referred clause D, which is relevant for recruitment. But clause D is not that illustrative. So we have to find out the scope of the rules by reading the other provisions of the Act. That's my submission. Now, when we explain the other provisions of this Act, Parent Act, the Commission has themselves decided to frame a regulations, and they have made certain regulations which is still existing, and the rules framed by the state now by incorporating this experience is inconsistent with the regulation. Therefore, the decision in respect of 2 is different, which cannot be done. Oh. Once more, yes, I'm sorry. Interview, if you kindly takes up the definition interview list. page 80 of the writ petition. Now, let only confusion arises because of the schedule where they have included this experience marks within academic. I had made submission that one is plural and one is singular. Now, kindly take some once the definition of interview list, page 80. Now, 80 interview list includes academic score. Submission was made by us that in no way these marks can be added at the time of preparation of interview list. Therefore, if we interpret academic score include teaching experience, then again it will be given twice, because in the merit list again teaching experience is included. Am I made myself clear?
1 minute. Academic score includes the prior
the
teaching
schedule.
experience marks as per the schedule.
Now, in
And-
interview list, the definition is
Yes.
this includes academic score.
Right.
If this academic score is interpreted in the way to include experience, then they have to give experience marks with at the time of preparation of interview list.
That is what they have done.
No, that is what they have done. But the submission was made, then this box will be given twice.
Why? How twice?
Now, kindly take some merit list once. Definition of
Yes, merit list.
means
That means there is mention about prior teaching experience.
again.
This was submitted earlier also. It is the same thing.
The same thing. I am trying to interpret in this way that they have included academic score at the time of preparation of interview list. That is the definition. May I read once?
Yes, I have followed this.
Means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the commission to be called on merit on oral interview and lecture demonstration category wise on the basis of preliminary merit score, that is score from written test, TET and academic score. If we add 10 marks on experience within academic score,
then what remains to be added at the time of prior teaching experience?
Merit, preparation of merit. That's all.
I don't know whether there is any other from freshers.
The supplementary list, item number 1.
It is there. Then দুটো বই সরান দাঁড়ান হ্যাঁ ফেরত দিয়ে দিন এই অর্ডার শিটটা মনে হয় 24,517 সাথে আছে যে Yours is Bishwajit Biswas. Freshers,
No, my lord, with the untainted teacher, I lost the job and I applied, my lord, for the 11-12 school. My lord, my contention is that the authority cannot take into consideration the experience of the candidates teaching classes in 9-10 for the 11-12. Whether any candidate get the double benefit. This is my contention. I am not supporting the submission of the landed senior advocate Mr. Bhattacharya. I am not supporting because I am the beneficiary of the 10 marks. Now, my lord, kindly see the gazette notification.
Prior teaching experience for 9 and 10 cannot be added for 11 and 12.
Yes.
Yes.
So because this, if the candidate applied the untainted teacher for 9-10 school, he untainted teacher and applied for the 9-10 school. When he applied for the 11-12, he will be the fresher.
He will be
the fresher candidate because they are untainted teacher of the 9-10 school, so they cannot benefit for 10 marks for the 9-10 school and 10 marks for the 11. This is my contention. But kindly see page 74 of the gazette notification. Schedule 2, my lord.
Yes.
Yes. Well, there is the, my lord, the clause A and clause B. Clause A for, my lord, the 9-10 school and clause B for the 11-12 school. Now, kindly come to clause A, subsection 2B. Prior teaching experience, my lord, the several occasions your lordship read this, my lord, the teaching experience marks. At the secondary level in the government or government aided or government sponsored school calculated on the basis of 2 marks for each year of service in a substantive post as permanent and contractual service. Well, this is categorically wise, this is the for the 9-10 school. And 11-12 school, kindly see page 75. 75, the B subsection 2 subclause, the B. This is the different clause. The selection process is the different and teaching experience marks should be the segregated. For the 19 school is a different and 11-12 is this is the contention of the as per the gazette notification. On the basis of the gazette notification, they have published the School Service Commission. The kindly see page 78. There's the
no, I mean
the notification.
In 9-10 also written marks is 60 and in 11-12 also written 60. In academics it is 10 marks and prior teaching experience is 10 marks.
Yes.
So it is the same thing.
Same thing, but what is the intention? Because the segregate, because if all are eligible, so there is the one clause. Because the 11-12 is the separate clause and 9-10 is the separate clause. This is the intention as per the gazette notification. So if every candidate they applied for the any post, so there will be the one clause. So because there is a separate segregated by this gazette notification, there is the schedule 2A for the 9-10 and B for the 11-12. So this is the segregation itself in the gazette notification.
Yes, but then apart from having two separate heads,
yes,
there is no difference in marks.
No, marks is not different, but teaching experience. So where I'm not teaching in the 11-12, so how can claim for the marks for the 11-12?
Yes, this
so that is the condition. But kindly see, the as per gazette notification, School Service Commission published the recruitment notification on 30th May 2025. Kindly page 78.
Yes.
Page 78.
Yes.
Annexure T4. Paragraph 2, third paragraph. The entire process is being carried in the strictly without prejudice to rights and contention of the State Commission and the Board of their pending review petition in the Honorable Supreme Court of India without intending to create any equity rights of the parties who may choose or participate in the process. The Commission, this is pointed out, this Commission reserve its right to cancel, withdraw, rescind and amend. This word is the hidden word, but on the basis of this word, they have changed their decision. In the selection process, this amendment clause is there. During the selection process, the selection authority can change anything. This is the strictly the bar, because the mid of the selection process, nobody can challenge nobody change the rule of the game. This is the amendment clause.
What is the amendment they have made? Have they made?
Because they have segregated in this their gazette notification. There is a separate category 9, 10 for 11, 12. Now they are decided, they are giving the both marks for 10 marks. Those apply for the 9, 10 and 11,
No,
12.
that the rules they say that it permits them.
Yes.
Then where is the problem? What is
Problem
the
is-
amendment?
Because they have decided the marks who applied for the 9, 10, they will get the teaching experience marks for the 9, 10 also.
That is the rules you are challenging.
Yes.
No, but then that has nothing to do with the advertisement.
Because they now they have given the marks to the all candidate in the both. That is why they are contested. They changed their decision. Initially, they decided they will granted the marks for the though apply the
Where
untainted
is the
teacher.
initial decision?
As per gazette notification, gazette
Yes.
notification is the separate clause and separate segregation. The 9, 10 will get the marks for the 9, 10 who applied for the 9, 10 school, and those applied for the 11, 12 will get the experience for the 11, 12.
Where is that mentioned?
Kindly see page 74.
74, prior teaching experience. It is not mentioned which class, which year.
No, year is not mentioned, but this is for applicable for the 9, 10 teachers.
That is, you are interpreting it.
Yes.
The way it has been placed in the rules. That means those in 9, 10, their experience in 9, 10
10.
classes will be considered.
Yes, yes.
And,
And
those
11,
in
12
11,
also 11, 12.
11, 12 experience will be considered.
Yes.
This is your submission.
Yes. And second, the part is the demonstration part, the 5 marks.
Which portion?
The 74.
74.
4, malad.
Lecture demonstration,
Yes.
10 marks.
They are working since in the year 2019.
Yes.
To till 31st December 2025. They have teaching the several student, but now they are again their teaching experience would be, this is the very for their cases this is not permissible, because
I
they have
cannot follow. I didn't follow.
they are teaching last 2019 to 2025
they are
they have
teaching.
teaching.
Yes.
So again they have given the teaching the demonstration. This is for the humiliating for the teacher, because
Humiliating.
yes, they have
You
they
lose
have,
your job.
no,
That is not
this
humiliating.
This is not for my fault, only fault of the school service.
So you show what you have taught.
So that is my contention, because if now the 2016 there is a professional qualification for the 5 marks, but now they have changed their 2016 rule. They insert the new rule for the lecture demonstration. That is for that reason.
If something was not there in the previous rule, can they not bring it in the new rule? Where is the bar?
This the Supreme Court said that in connection with the 2016 rule, they conduct the selection process. But this section is a totally new section, new clause. So that is I am challenging. Now, there is the another clause is there. The in part of the section, what is amendment was this the judgment of this Saurabh versus the Aligarh Muslim University.
All right. Yes, what sort of,
2009 4 SCC, my lord, 5.
what is the ratio over there?
Ratio is there, my lord. They cannot change the, my lord, the rule in the midway of the selection process.
When did the selection process commence?
Commence, my lord,
2016?
2025.
25, it is continuing. Where is
In-
the change
In
in
the
between?
midway, my lord, they have
What
decided.
is the midway?
This is during the selection process. Initially, they decided the marks given for the this separate for the 9, 10, and 11, 12. Now
No,
they are giving.
this is the notification that they are following. They have not come up with any new notification or new regulation.
No, they subject to lordship correction, my lord. They initially decided they segregated to separate 2 clauses for the 11, 12, and 9, 10. My lord, now they have given the marks they applied for the 9, 10, and 11, 12 with double benefit. That is, my lord, the.
Listen, at the time of filling in the application form, you have filled in your prior teaching experience, whether 9, 10, or 11, 12, or whatever. That point of time, you did not challenge.
No,
right?
Because as per notification, I think this is segregated because nobody will be granted the double benefit for the both.
Yes, I followed. This is not required. There is no amendment.
So this is the contention, the as per the petitioner prayer before your lordship, because the marks should be granted for the each applied for the which post, not for the both the benefits should be granted by the School Service Commission. Last occasion, lordship the added respondent also given the direction upon that to file affidavit.
Have you prepared?
Yes. No.
The
Nobody has filed
responsible
that affidavit.
All right, they will. The hearing is
But
continuing.
one thing, the last occasion, your lordship was pleased to pass an order. I challenging the rule because I have beneficiary of the rule. I have not against the 10 mark. Now that is kindly clarify.
Your lordship, direction for filing affidavit was there, my lord. My lord, in item number 20, we are filing the affidavit on the opposition.
You are another co-applicant.
Your lordship, last occasion added our applications and added as a respondents. my
All
lord.
right.
We are
So
filing
private
opposition in item number
respondents.
20.
Private respondents. All right.
Can 6, my lord, application for added party, already added. I am supporting the writ petitioner, prayer of the writ petitioner. Can 6, there are 41 students.
All right.
On the same relief, paying for same relief, my lord. My teachers.
Yes. এটা সরান্ত ওটা কাতে কোনটাতে দিল অপোজিশনটা আইটেম 20 আর এইটার list. Did anybody file the opposition?
No.
No.
This you did in item 20.
20, man.
All right. Is the commission aware of the supplementary list matter?
Supplementary list, my lord, the matter which was just taken up.
Yes.
Vishwajit Vishal.
Yes. Any opposition prepared?
No, my lord, no opposition, but we'll be giving.
Prepare it and serve.
Get no.
One opposition that we have prepared and filed today.
In which item?
That was in item number 38. Our contentions would be fundamentally the copy pasting. So it's the same thing.
Yes. SLST মামলাগুলোকে না আলাদা একটা বান্ডেল একটা হেড করবেন
My lord, for convenience, I shall be referring to only one set of documents because the law points are 3, 4. Lordship need not
যেটা যার
travel.
সাথে কিন্তু রাখবেন ঠিক করে, তা নাহলে প্রবলেম হবে। 24899 ঠিক আছে। Yes.
May I begin? My lord, my
First of all, tell me your status.
my lord, I was appointed. I served after thorough scrutiny of all the candidates by the CBI. My OMR was found to be genuine, no mismatch. Total number of counseling was done 1 to 8. CBI found 1 to 7 as a valid. Yes.
Just now one has started.
Yes, I just started.
One has started just now.
I
Order means which order?
Seniority or something like that.
Somebody who's here, I'll hear. Don't worry.
No, there was an understanding that since the private part.
Sir, I'll hear you. Do not worry. Please wait. I'll hear you. Yes. Yes. I'll hear you.
I'd like to know when my turn is like because advocate will speak for the state.
No, state will be separate. Respondents, I'll hear separately. Let the petitioners and applicants be heard. No, he is not the respondent.
In the entirely for a lawsuit, that's what Lalit will say. Lalit said the precedence of who will answer for you.
But that
Let her get her turn. I'll hear you. No difficulty, whether today, tomorrow, because you'll be here.
argue before me, I have absolutely no difficulty.
Please come. Please
No,
come.
that
You
is-
can start. Please come.
I'm grateful.
Because
24899 Bhim Sarkar, is your application for addition of party there?
It's allowed, my lady.
It's
been
there. You have an application over
Yes,
there.
yes.
All right. And what is your status?
Yes, my lady, we are untainted teachers. And I
Alright.
say teachers because I want to. I say teachers because we are presently teaching in the government school system all over this state. And we have been teaching so for almost 7 years. So in that sense, we form a backbone of education in government schools in the state of West Bengal. Now, in 2016, because my lady had posed this question on Friday, and these are the numbers, because my lady must have the big picture of what you're hearing today.
Yes.
In 2016, there were 18,617 vacancies. I want the table of all the cans were appearing. Get me that. 18,617. In 2025, there are 35,657 vacancies that were advertised by the government. Now, why are these numbers important? Because amongst the various petitions, my lady is also seized of petitions by freshers, meaning applicants in that classical sense, who are applying for the first time and took the 2025 exam subsequent to the decision of the Honorable Supreme Court and cleared that exam. Now, this court is seized of a situation which is highly unusual, because it is a rare case where a court is seized of a situation where you have existing members in a service and entirely fresh members in a service taking the same exam. It never happens. So my lady is seized of a unique situation which amplifies service law, constitutional law, administrative law, and of course with the CBI investigating criminal law. But in the realm of constitutional and service law, you rarely have a case where existing personnel have to take the exam which they cleared 7 years before again for no fault of theirs. So when I present myself to you, who do I represent? I represent an individual who has 4 qualities. One, I am entirely untainted. I have indulged in no wrongdoing. Firstly. Two, I have been performing my job with honor and rigor. Why do I say this? Because not only have I been teaching for now almost 7 years, but my lady knows well the multifarious obligations and functions of a school teacher. Election duty, invigilation
Yes,
duty,
yes,
so on
yes.
and so forth.
Right.
So one of the many petitioners I represent, and there are 13,000 such teachers. One could not be today in court because he's doing invigilation duty for an exam. While he is teaching, he has also done invigilation and he has taken the exam afresh for no fault of his. Now, in 2016, if my lady will just make a note of this, 17,209 teachers were appointed, tainted and untainted. In the 2016 teachers who appeared in the 2025 exam, the untainted, is 13,800. And I speak for a substantial majority of all of them. Now, you have had, just to, again, who is taking this exam? Since we are here, multifarious categories, all arguing different aspects of the rules. And my lady is seized of the virus of the rules. That is what is before my lady. Fresh candidates, just to give you a sense, for grades 9 and 10, fresh only, fresh candidates, 2,70,000 applicants, candidates who appear. And for 11 and 12, 2,18,000. And many of these overlap between 9 and 10 and 11 and 12. That is to give you a sense of the magnitude that is the exam, the number of young people who apply for this exam, and in so many ways, all these young people, whether they are freshers, whether they are not so young, the existing teachers who form the backbone of education in this state, have all been let down by this process of examination, recruitment, and eventually that we are before my lady. Because rare is the case when the innocent have to suffer the trials and tribulations of adjudication twice over. It is a rare case. In criminal law, we say no double jeopardy. In service law, we have no language for it. But that is who I am and how I am before my lady. Now, the first point I want to make, my lady, and I'll demonstrate that through the data, is this. Is that the number of vacancies today under the 2025 process is almost double than what it was pursuant to the 2016 process. In fact, in the Supreme Court on Thursday, Justice Sanjay Kumar was hearing this case and reposed confidence in my lady to hear all issues correctly. Made this point that I never expected the state government to reopen the process to fresh candidates. I thought you would only, in fact, have this exam for those who are teaching and untainted. That was his case. So that was the element of surprise. But that has been now dealt with by the fact that you have almost double the number of vacancies. And I will take my lady through the data to show that a substantial percentage of those who succeed through the exam system in 2025 are freshers. So they are not burdened by the 10-mark rule, which I will subsequently argue is rightly been given by the state in this context. And why do I say that it is rightly been given? Because, my lady, there is great value to teaching experience. And the teaching experience in this case of 7 years means you have a super qualified teacher who has 7 years of experience in the classroom. Mathematically, I was trying to put a number to this. What does this mean to have 7 years experience? Because it is very difficult for a court, which is not an expert body, engaging what is the most efficacious teacher. But mathematically, what does this mean? This means that if you have roughly 13,000 existing untainted teachers who've been teaching for 7 years, teaching roughly 225 days of the year with holidays, etc., into 8 hours, you would get an extraordinary number of 14 crores 4 lakh teaching hours that these 13,000 candidates have between themselves. And I should say these 13,000 teachers have between themselves. And what does that mean in terms of enhanced efficaciousness in the classroom? We can imagine what that means.
No, that means you are supporting the extra
Yes,
prior.
yes.
Yes, I get it.
I am supporting the extra
Then
10
what?
marks, which is 2 marks per year of teaching.
Right.
And so at 7 years, I'm actually not getting 2 marks per year. I'm only getting marks
For
for
5
5 years. And that is only being counted once, not twice, not thrice, but exactly once. I'll go to the rules subsequently.
And you are for the 9, 10 or the 11, 12 batches?
Both, my lady.
Right.
9, 10, 11, 12.
All right.
This is who I'm for.
How
Now,
do you substantiate the allegation that the
experience that the rules contemplate, and I'll take you to the rules in specific immediately. The experience that the rules contemplate is experience within the classroom of higher secondary. There is not a grade, because the nature of the teaching experience is also subject specific. I'm going to take you to that to show you how the intake is also subject specific. So in that sense, there is no great difference because the subject specificity is also there. In fact, I want to show you what I'm actually discussing. Can I just have this? Yes. I want to see the subject. So firstly, my lady, may I just hand over? This is the preliminary interview panel. We've just picked this ad hoc, 11 and 12. My lady has this?
Yes.
This is the preliminary interview panel, SLTS 11 and 12. I've just picked 11 and 12. Equally so, we can show my lady 9 and 10. Freshers versus in-service ratio %. I'm going to make good on my claim that anyway the freshers are protected. Please see. You'll see that the intake is subject specific. For instance, there is accountancy, agriculture. These are all specific subjects that are offered by the schooling system, 9 to 12. And I have to demonstrate expertise in this. Now, please see, for instance, since it's a top of the list, accountancy. 92.86% of those who successfully get to the interview panel, meaning clearing the exam, demonstrating qualifications, are freshers. Only 7.14% are those with experience like me, untainted experienced teachers. So, similarly, my lady, please appreciate the entire list before you. These are all the subjects that are offered in the higher secondary schooling system. Agriculture, 66% of those before the interview panel are freshers. Likewise, if I randomly pick economics,
agriculture is not there in 9 and 10. Agronomy is not there. Anthropology is not there.
11 and 12. This is what I'm
Right.
demonstrating to you is 11
So
and 12.
11 and 12 experience is all right.
Yes.
But somebody in classes 9 and 10,
yes,
how can experience marks be counted for 11 and 12?
Because the nature of what the rules contemplate to be experience is the experience of having taught students in the classroom. That is what
does
the
it mean?
rules.
Does it mean suppose I have taught 5, 6, 7?
It would not, my lady. Respectfully,
yes.
it would not.
It will not
Because
be. The primary classes experience, the
Yes.
secondary classes,
Primary,
the upper primary
school
is different.
and high school or higher secondary school. Higher secondary school is classically 9 to 12.
Higher secondary starts from 11 and 12.
Yeah, no, my lady. 9, 10, 11, 12
9,
is
10
what
is secondary.
May I just take you to the rules? Secondary. May I
9 and 10 is secondary.
Yes. May I just take you to the rules now? May I just take you to the rules? Yes, I want to, which SLP? My lady, would my lady have the compilation that I'd handed over last week?
there in Vim Kumar.
It's in?
In which matter did you hand it over?
Kumar.
Vim Kumar.
Vim Kumar.
This spiral one.
This spiral one, which is just next to you.
In this? देखिए तो where the compilation actually.
We can just hand over another copy.
দান এটাতেই আছে বোধহয় ওই বড়টা দেখাচ্ছে তো এটাই হবে নিশ্চয়ই দেখি দেখি একটু ঘোরান সেলাইটা দেখি না না এটা অন্য লোক দিয়েছিল Do you have a back sheet? Is it under a back sheet? No, no, এটা নয়.
No, my lady. But we have another copy of the same compilation that we handed over.
Let me see once if it is here.
Spiral bound. No. It was
ওটা দেখুন না ওটা কত মোটা না এগুলো নয় ওগুলো নয়
Yes.
ওগুলো নয়
It's page 503.
ওইটার নিচে কিছু নেই নীলগুলোর নিচে নীলটার নিচে কি আছে voluminous one, in which matter did you tag
In
this
Vim
up
Kumar,
with?
Vim Kumar, my lady.
This is, I am having Vim Kumar with me.
It was put away in a very nice red colored.
Oh, it was also.
spiral.
I think this may be it. This it? Let me just see. No, my lady, this one.
No.
This is Vim Kumar, but this is not the compilation. And my lady had marked up also passages in it.
তারপরেরটা
Mandal.
Is it the convenience compilation? This one?
Yes, my lady. Yes, my lady. Yes.
All with the blue sheet. That is the reason it got mixed
the
up.
blue sheet. Convenience compilation of judgments and documents.
Yes.
Now, may I just take you to page 503?
Yes.
And this is the main statute, West Bengal Board of Secondary Education Act 1963.
Yes.
And may I just take you to page 503?
Yes.
The definition of secondary education. And this is all I seek to rely on. My lady has page 503. I should actually say H on 502 is primary education. And secondary education, my lady has that 503L, KL. Means general education above the primary education stage provided for students with a view to qualifying them for admission to a certificate, diploma or degree course instituted by a university or by government or by a statutory body and includes subject to any general or special order of the state government, technical, agricultural, commercial, so on and so forth, or any other type of education which the state government may, in consultation with the board, specify. Now, may I take you to 547? This is the schedule.
Yes.
So, my lady, this is the generic understanding of secondary education. I would respectfully submit that this would constitute 9, 10, 11, and 12.
Secondary.
Secondary education.
All right.
Secondary education. Now, please see the page 547. My lady has that.
Yes.
Schedule 2.
Right.
Please see. Schedule 2. Now, the first segment of the schedule is with reference to classes 9 and 10. May I read? Selection to the post of assistant teacher for classes 9 and 10 shall be made on the basis of marks obtained in written examination, educational qualification, prior teaching experience, oral interview, and lecture demonstration determined by the Central Commission in the following manner. I'll just stop here for a second. Now, earlier in the morning, one of my learned friends actually makes this point before my lady, that this is the first time that prior teaching experience is part of the rules and delegated legislation. Now, the answer to that is, but obviously, my lady, because this is the first time that existing teachers who have taught are being forced to take an exam again for no fault of theirs. So, the rules are in response to the reality that is the situation that faces the state and my clients, the untainted teachers. You could not have contemplated this situation. I mean, I suppose if you had been more diligent about the system itself, then we wouldn't be in this unimagined situation. I should say that. So therefore, the rules which are passed, keeping in view the Supreme Court's judgment and the related situation of recruitment for the posts of teachers, and I know staff are also before my lady, but I'm only on teachers, was uncontemplated. The rules then had to be passed to address the judgment of the Supreme Court and the situation that I find myself in today. So it is not a surprise at all, nor is it of any relevance that the rules in the past did not have this language. So that is my second point. Now may I continue reading? So selection to the post of assistant teachers for classes 9 and 10 shall be made on the basis of marks obtained in written examination, educational qualification, prior teaching experience, oral interview, and lecture demonstration determined by the Central Commission in the following manner. Written examination, that is OMR based, 60 marks. Academics. Now, this is the crucial phraseology. Academics is part 2 of Schedule A2 now. A2 has 2 ingredients. Under the subtitle, the subchapterization of academics. A, educational qualification, 10 marks. Based on marks of graduation or post-graduation in the subject for which applied, whichever is higher according to the following formula. So within educational qualification, the 10 marks are given. There is a meritorious component to it, which is tied to the percentage you've obtained. So this is explicitly tied to the percentage you've obtained. So for instance, may I just show you a sheet of who are some of the untainted candidates to just give expression to what this component means. Can I just have that sheet? Yeah. Where it shows the marks they received. And
Now, how does it matter?
yes, it matters because in the wisdom of the legislature, we are assessing when my lady is seized of the virus of the schedule and the virus of the statute. My lady is being asked to address and assess and adjudicate upon the wisdom of the legislature. And in the wisdom of the legislature, it is not only 2 classes that are created of those with prior teaching experience and those without prior teaching experience. There are a manifold classes that are created in these rules. Please, so we cannot only look at one categorization independently and in vacuum. The legislature and the executive, because they rightfully have the expertise, are creating a hierarchy of preference. One of the preferences is what is the percentage you have received in your written examinations, and that we call educational qualification. And you will see that, of course, classification is created here. That classification is if you have received 60% and above, you get 10 marks. Now, somebody who gets below 50% is disadvantaged because they only get 6 marks. But that is the space and the sanctity we accord the legislature and the executive, who in turn have experts to advise them in terms of how and what they should prioritize. So they are not just creating one zone of priority, which is past teaching experience as a teacher and no teaching experience. They are creating many zones of priority. Now, when the legislature and the executive creates manifold zones of priority, what does the Constitution say to this? The Constitution, after all, assesses. We are not Britain, where Parliament is supreme. We are India, where there is separation of powers. And the Constitution then is expected to look at the objectives of the legislature. And the only test which my lady, I would respectfully submit, would in fact take into account is whether the rationale is, the objective is rational. And here you will see that the rules and Schedule 2 creates a manifold sense of priority and preference and hierarchy and whatever we may call it. The first one, my lady, is merit score in terms of educational qualification. Now we come to the second one, but not the only one. And I will take my lady to the third and the fourth. Now we come to the second one. Again, is this rational? Is at best the only lens that the court can, in fact, look at it with. Because anything beyond that you would traverse into the area of expertise, which respectfully, my lady, because I certainly don't have it, nothing in legal education prepares you to assess what makes a perfect teacher and what makes a better teacher. Because when we enter into that realm, which respectfully separation of powers prohibits us in the legal domain from doing so, we are entering into a debate that then should extend to what makes a better pilot in the armed forces, what makes a better general in the army, and what makes a better surgeon in government hospitals. This is a realm which the court has never navigated because of, my lady,
Lack of expertise.
Judges are full of wisdom, but maybe not expertise in recruitment requirements.
Yes.
That's all, with great respect. That is as far as I want to go on that. But there are two arguments that I'm presenting. And at the end, my lady, when my lady reserves judgment, I'll submit a note. But the two arguments that I'm presenting before you is one, my lady, that prior teaching experience is not the only classification. And two, my lady, that what constitutes preference and priority for the recruiter, in this case, the employer, in this case, the commission, is for them to decide. The courts are very capable of looking at a recruitment system and saying, is there fraud? Is there cheating? Absolutely. That is the domain of the judiciary. But this, my lady, respectfully falls outside the realm of separation of powers, outside the realm of expertise, and outside the realm of what a court can assess. Now let's go to the third step of why courts don't have expertise. Courts don't have expertise because, one, they are not fed with the raw data of how many vacancies. Two, they are not fed with the raw data of what makes a better teacher. Three, they are not fed with the raw data of what all functions teachers have to navigate. So the experienced teacher right now, one of my clients, is out having taught in the morning, invigilating in the afternoon, worrying about his court case in the evening, and also having written the exam again. This is all that experience gives him the tools to navigate. And there is value in that experience. I have only very crudely given it a numeric value, 14 crore teaching hours. Ought that not to have value? And does the legislature not have within the constitutional scheme the ability to ascribe enhanced value to it? Respectfully, my lady, a court will not be able to assess what it means to have that value. But is it a rational objective for the court to say, yes, this is rational in terms of better returns, better efficaciousness in teaching, and in fact, in spirit also, implementation of the Right to Education Act? Is that object rational? As long as it is a rational object, my lady, respectfully, the court must then demur from there.
All right.
Yes. And my lady, respectfully, I'll take my lady very briefly to Arunima Pal, where the court says that. And my lady is right on the general discussion, some of which may be obiter. Absolutely, I bow down, and I think that debate has been set aside. But on how and who has expertise, the division bench in Arunima Pal provides some light. Now, may I take you to the third criterion in Schedule 2? Oral interview, 10 marks. Yes, my lady, before I go any further, prior teaching experience, 10 marks. At the secondary level, in a government or government aided or government sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or on contractual basis. No doubt, my lady, you will have petitions on permanent and contractual also. I'm not on that right now. Now, please see criterion 3. Oral interview, 10 marks. 4. Lecture demonstration, 10 marks. Appearance before the interview board is compulsory. So, in this realm of academics, because the language and the terminology has repeatedly been contested before, my lady, in this realm of academics, there are only 2 components. 1, educational qualifications, meaning prior, and 2, prior teaching experience. What is interesting about the component that is academics is both of it pertains to prior conduct before the exam. And that is where both these components are in consonance and in harmony. That is the intention of the legislature. So in Schedule 2, I would in fact place a contrary argument that the legislative intent is in perfect harmony. The legislature is very clear, my lady, that you have to take the exam, the written exam, that is A. That is the present. This is your present test, the written exam. 2, academics is your past. The marks you got before and the teaching you had before, because I'm very sorry, we did wrong to these 13,000 candidates who have been fulfilling their job dutifully and with honor and honorably. Now, 3 and 4 is subsequent to the written exam then, oral interview, lecture demonstration. Now, in the scheme of how you assess, when do you take these 10 marks of prior teaching experience, my lady, even if you see the scheme of the schedule, it has to be before the interview. Because the interview process, any interview in service law, any interview to public employment for a public employment position is the culmination. It's a pyramid. You show that you have the basic qualifications here, educational qualifications. You show that you have cleared prior to that the written exam. You show that you have, in this case, prior teaching experience, and you culminate that with the interview. The interview process and system, the panel for the interview, will have the least number of candidates because the sifting starts from the base of the pyramid upwards. You never have in service law the situation of a funnel. That is what my friends are asking for. If they ask for the prior teaching experience to be considered at the interview stage or after the interview stage, they are asking for this diagram. And that is unknown in service law because the interview is expected to be the culmination after your documents have been verified. I'll take my lady to the rest of the statute, which shows when is the verification done. Because after all, one way of verifying is in fact also checking that I am employed by the court, by the education system, to assess the fact that I am employed and therefore I have experience that is recognized by the statute. It is not any experience. It is experience which the legislature in their wisdom chooses to recognize. Now, my lady, part B. May I read, my lady? Yes. Selection to the post of assistant teacher for classes 11 and 12 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience, oral interview, and lecture demonstration determined by the Central Commission in the following month. Now, please see, my lady. It's almost identical, but when we go page over 548, you will please see under prior teaching experience 10 marks, it simply says at the secondary level in a government or government aided or government sponsored school calculated on the basis of 2 marks for each year of service in a substantive post. I will respectfully request my lady to underline this at the secondary level. And the secondary level is 9, 10, 11, and 12. Oral interview, lecture demonstration. Now see. Please see. The distinction that is made by the legislature between the secondary level and the upper primary level. The upper primary level selection to the post of assistant teacher for upper primary level of classes shall be made on the basis of marks obtained on academic score, TET weightage, marks in written exam, marks in oral interview, marks for lecture demonstration, marks for prior teaching experience, to be determined by the Central Commission. So this segment of the schooling system is desegregated from the secondary level segment of the schooling system. So it's not everything that is put together, but it is secondary that is put together, and now this is upper primary.
No, upper primary is different.
After 5 till 8.
So 6, 7, and class 8 would be upper primary. 6,
5, 6, 7, 8.
5, 6, 7, 8 would be upper primary. 9, 10, 11, 12 would be secondary. These are the segments. And this is the assessment that is done eventually by the interview panel, which is looking at everything that funnels into 9, 10, 11, 12. And that is distinct from upper primary level, which is 5, 6, 7, 8. And primary, of course, would be 1, 2, 3, 4. So these are the 3 segments of how education is also understood. And it is understood because it is also, there is science as to how children's brains develop. That is what it is, my lady. Now, my lady, may I take you? My lady, may I have a sip of water?
Yeah, sure.
Okay. Thank you.
No,
Yes.
9, 10, 11, 12.
Now, my lady, as my learned friend rightly points out, in practice, and this is based on conversations with the teachers, and we have also annexed some information on that. In practice, teachers of 9, 10 are often assigned 11, 12 classes due to vacancies and administrative limitations. So there is that kind of exchange that goes on. And they also serve as examiners or evaluators for higher secondary examinations. And this we have enclosed, my lady, in Annexure C, page 22 of Can 1.
In the Biswajit.
In Biswajit Biswas, which is writ petition number 25015 of 2025.
Can 1 Vishwajit Biswas. Can 1 of Vishwajit Biswas. That's it.
Yes. Yes.
That's it.
And when I give my written submissions, I'll extract all of this for my lady. So it's all in one place.
Yes, what is it that you want
Now,
to rely?
My lady, I'm sorry.
What is it that you want to rely?
Only this, that within that realm of 9, 10, 11, 12, there are a lot of duties that are inter se exchanged in that category of teachers. That's
All
it.
right.
Only to that extent. And we'll extract it when I give you my submissions. Now, my lady, what is the law when it comes to prior experience? This because I've shown that prior experience is categorized. It sounds very logical. Well, what is the law on it? And this is the law that I'd want to take you to. Firstly, my lady, and we've given this append in on page 485 of this compilation. The UGC, छोड़ दीजिए, कोई बात नहीं, ठीक है, छोड़ दीजिए, group discussion भी छोड़ दीजिए.
485?
485. The UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for maintenance of standards in higher education. These are the regulations of the UGC 2018. May I just take you to page 485? The regulations start at page 435, my lady. My lady has that. 435. Page 435.
Yes.
Within the compilation. This is the UGC regulations on minimum qualifications for appointments of teachers and other academic staff in universities and colleges and measures for the maintenance of standards in higher education. So this pertains to all UGC regulations all over the country, my lady, as it pertains to the central government. Now, from this, and my lady will see an exercise of powers conferred by the University Grants Commission Act. These are the minimum qualifications for appointments of teachers. This is a macro at an all India level. Now, please see, and the short title, application and commencement, these regulations can be called so-and-so. They apply to, my lady has this 1.2.
Yes.
They apply to every university established or incorporated by or under a central act, provincial act, or state act. Every institution, including a constituent or affiliated college recognized by the Commission in consultation with the university concerned under Clause 1 of Section 2 of the University Grants Commission Act 1956, and every institution deemed to be a university under Section 3 of the said Act. So you can see the remit of it. Now may I take you to page 485 of this, table 3A. My lady has this 485, middle of the page. Criteria for shortlisting of candidates for interview for the post of assistant professors in universities. Please see serial number 7 on the same page. Teaching, postdoctoral experience, 2 marks for 1 year each. This is prevalent. This is upheld. I'll take you to case law. So my lady may please just mark this page. And this is at a national level that this prior teaching experience is given an accorded preference to. And this, my lady, was upheld. I'll take you straight away to the case. Allahabad University, page 188 of the compilation. Page 188. Yes, relatively new case, my lady, 2024. SCC Online, SC 376. Justice Dipankar Datto writing. So if my lady goes to page 190, you'll see exactly what has been challenged, what I read to you. As per clause 7 of tables 3A and 3B, 2 marks are to be granted to a candidate for every year of his or her teaching experience or postdoctoral experience. Since the contents of both the tables are similar, we propose to reproduce 3A later in the judgment. So exactly what I read to you. Now it's being tested before a bench headed by Justice Datto. Now, please, may I take you to page 215. Paragraph 45.
Page
15, paragraph 45. Now, this is the conclusion on the test. Even otherwise, we find no my lady has this.
Yes.
Even otherwise, we find no justification to uphold the view taken by the division bench of the High Court. It was never the intention to deprive aspirants of marks for their teaching experience as assistant professors, albeit for shortlisting purposes. So, for shortlisting purposes. So, 2 things are happening here. One, you are saying that you will give that experience, and 2, you are using that experience to shortlist. The pyramidical structure with the interview being the culmination. Now, please, I'll continue. Conditions of eligibility for entitlement to secure marks which have been laid down are matters of policy over which the courts have no expertise. Judicial review would not extend to cases of the present nature where regulations are framed by experts having a fair measure of idea of what is required and what is not for appointment of teaching posts. the division bench overstepped its limits and treaded a territory which was forbidden. Now, may I take you, my lady, respectfully to paragraph 47. Page over, my lady. Page 216. May I read? Yes. Above, we have assigned reasons why the High Court was not justified in its approach. Independent thereof, there is one equally weighty reason for allowing the instant appeals. As discussed in MP Public Service Commission, I'll take my lady to that. A recruiting authority is well nigh entitled to adopt a method for shortlisting candidates on some rational and reasonable basis where selection is required to be made only on the basis of an interview. In the present case, note to Regulation 4.1 relating to assistant professor ordains that after shortlisting of candidates based on academic score, again, this is the same language, academic score specified in tables 3A and 3B, the selections shall be based only on the performance in the interview. So once you have culled all of this, you have arrived at your shortlist in the language of Justice Datto, you then invite these shortlisted candidates for the interview. In the course of hearing, we were informed by Learned Senior Counsel for Allahabad University that 69 candidates were shortlisted and called for interview, the cutoff marks being so-and-so, who were competing against each other for appointment of only one unreserved vacancy. Respondent 1 had secured 81 marks, and between 87.17 and 81, there were 147 candidates. I'm just